A kind indulgence of my lords to item number 22.
No adjournment. Hearing matter, no adjournment.
My lord, just very fairly submitting. I conveyed to the government council yesterday.
It's fourth time.
I understand.
On your behalf, it has been adjourned.
Well, kindly accommodate me after summer vacation. Lord. I could not leave my hands.
What's there? We'll assist you.
No, my lord, that will not be fair. Although the niceties of bench and bar is there, sharing, exchanging few niceties, but then today I am not ready, my lord.
That's why I did fourth time.
I understand, my lord. Kindly accommodate.
On your behalf.
Well, sometimes I was out of station.
What to do?
After
Okay.
After summer vacation, any day, my lord.
Mr. Titi Learned Senior Counsel submits that he has some difficulty to argue the matter. Therefore, praise for listing of the matter after 3 weeks.
Any day, fine, my lord, after 3 weeks.
MS prayer is allowed.
I have informed
Accordingly,
Mrs.
list this writ appeal after 3 weeks.
I'm grateful.
MSP Pangulan State Council to the respondent. Respondent number? All the respondents.
All the responses.
Respondent is present.
Grateful.
May I please, my lord? My lord, I beg to mention item number 4. The brief is with my junior, who is right now at Coloria. So he kept the brief with him.
He has taken the brief along with him.
He has actually
To Coloria.
he taken from me to Xerox out from the master copy to furnish a copy to the LSC, my lord.
Very,
So he
very,
didn't return to me.
very careless junior.
So my lord, matter maybe this after 3 weeks, my lord.
Yeah, probably only the step was not yet taken.
You take steps, let us see. I think you're supposed to take steps. Let's see.
No, already step been taken.
Let us see.
My lord, we are on behalf of respondent number 14 and 15.
In item,
Item 1.
Madam, we are on item 4.
Oh, what? Okay, sorry.
Autumn Mori has been appointed for respondent number.
Yes, I'm for the victim.
Learned counsel for the appellant
Yes, my lord.
submits that unfortunately the brief has been misplaced.
Petition, yes, my lord.
Misplaced.
At Coloria, my lord.
No, we'll not say all this thing. You need to pull up your junior. What is it? Misplaced. I mean, that brief has been misplaced. Therefore, he is not in a position to argue the matter today. Therefore, praise for listing of the matter after 3 weeks.
All right, my lord.
Mr. Prayer of Mr. Antaji Learned Counsel to the appellant is accepted. Accordingly, list the matter after 3 weeks. Mr. U body. Then LSC.
No, MIKS.
Mike Learned MSKD is present.
Hello.
My lord, I beg to mention item number 5, my lord.
Yes.
My lord, if this matter can be taken after vacation, my lord.
I think
All the
Item number 5.
paperwork need to be prepared. I think. Paperwork need to be prepared.
okay. Paper book has not been prepared.
Not prepared yet, my lord.
Say, on the prayer of Mr. El Kurdu Learned Counsel for Learned Special PP within bracket SIT bracket close. List this matter after 4 weeks next month. In the meantime, raised it to prepare the paper book, right?
Obliged.
And my lord.
Yes,
One
please,
more
your
item.
lordship. Lordship, I beg to mention item number 2. With due consent of the other side, made a matter may come up after vacation.
On the prayer of MS,
S. Sharma on behalf of Mr. B.K. Singh.
S. Sharma appearing on behalf of Mr. B.K. Singh, learned counsel for the appellant. List this matter after.
Lordship, fixed
And the
date may
prayer,
be given.
and the prayer not being objected to a learned counsel for respondent, Mr.
M. Taso.
M. Taso.
On behalf of Senate.
List this matter after 4 weeks.
Lordship, fixed date may be given.
Why? When you are making when the matter is listed, you are seeking adjournment and then you want the next fixed. Two eight. Yes, yes, next.
My lord, item number 19, my lord. Here, senior counsel PD Nair will be appearing, my lord. So can this matter fixed on 30th of this month, my lord? 30. 19.
What is to be reviewed?
My lord, there was observation from the Supreme Court, my lord.
To
That-
file a review.
Yes, my lord.
Probably they took time to file affidavit, not yet filed.
After vacation,
My lord, 30, my lord, can it be 30, my lord? Because, my lord,
Supreme
there
Court is
is,
directed to dispose of the matter.
my lord, actually, urgency is there because we are yet to ascertain if work is still progress or is,
You ascertain, will take after 4 weeks.
my lord, if it can be taken, I have taken consent from other side also, my lord. It can be fixed on 30th of this month, my lord.
30.
30, my lord.
Okay.
Okay.
On the prayer of Mr. L. Kudu, learned counsel for the review petitioner, list this matter on 30th, 06/2026. Yes.
Applies.
When you have filed an SLP or appeal before the Supreme Court, why review has to be filed?
My lord, as because there was direction from the Honorable Supreme Court saying
What
that,
is the direction?
saying
You
that,
have sought, you have withdrawn the petition and then sought
My lord,
liberty to file review.
the Honorable Supreme observed that, my lord, the ground which you have taken in the SLP, my lord, that ground we have not taken before the, my lord, before the division bench, my lord. So that is why, my lord, they are directed if permissible review may be filed,
Okay, we'll dismiss on 30th.
my lord, on that day, my lord. Publish, my lord.
My lordship, I beg to mention item number 6. The conducting counsel Vinyarus is out of station. Consent has been taken from the PP.
Okay, on the prayer of Mr.
After some
MS
M. Jarang.
M. Jairam, Land Council, appearing on behalf. Your name is there, no?
No.
On behalf of Mr.
Vinyarus.
MS. Mr. or Miss?
Mr.
Mr. Binyarus. List this matter. List this appeal after 4 weeks.
Okay, much obliged.
Yeah, Your Lordship. Your Lordship, I beg to mention item number 18.
18.
Your Lordship, I'm appearing on behalf of CGC, Mr. K. Lawyer. Your Lordship, the learning CGC is out of station. Therefore, Your Lordship, this matter may kindly be fixed after a week, Your Lordship. We have taken consent from the other party.
On the ground that Mr. K. Land CGC is some personal difficulty today. MS
Oh, Jarang, Your Lordship.
Ojera, Land Council appearing on his behalf, prays for listing of the matter after 4 weeks. Prayer not being objected by Land Council for the petition, the respondent that this matter be listed after 4 weeks.
1 week, Your Lordship.
Huh?
1 week, Your Lordship. After
1
a week,
week.
Your Lordship.
Then 1 week.
Much obliged.
Please, Your Lordship. My Lord, I beg to mention item 10. Here, my Lord, I'm appearing for respondent number 5. Due to some misunderstanding, the brief has been taken away by the client for some reason. But it was supposed to be returned did not return. So maybe
Not say anything.
uh,
Say,
no, they wanted to file case in the lower court also. So they wanted to know the things. Then later on, I think they forgot to return. I also forgot. So my lord, it may be taken up after a week or 2 weeks, my lord. So lordship.
you are too young to have that kind of position.
My lord.
Slowly, we're getting we're reaching.
Only this morning I realized that is
I'm
missing.
saying that position you are yet to reach, unlike us.
Maybe I'm too
Just
advanced.
started. We're just stepped in.
That's why I was finding it very embarrassing to mention also.
Okay. I will not say anything, but
Yes.
I'll just on the prayer of MSN Nugget Learned Council for the respondent.
5.
Respondent number 5. List this matter after 2 weeks, 3 weeks.
2 weeks, 2 weeks, my
2
lord.
weeks. Yeah.
My lord, also I beg to mention item 21.
Hmm.
Here I'm appearing for the appellant.
Hmm.
I've seen the paper book.
Hmm.
It's incomplete. They, not only in this case, in fact, I've seen in many other cases also, they forget to put the 161 statements.
Hmm.
It's would be relevant, especially in this case, I feel.
161 will be available in the record only.
Yes, it should be have been in the paper book. They have not.
161 is not in the, it should not be in the paper.
In some cases, they do put because it's.
161 is not required.
Otherwise, I was thinking that maybe I would just apply for a.
161 would be in a record only.
Apply for a.
Found it correct.
Yes. In some cases they put, in some cases they don't. I was feeling that maybe it would have been better if they put the 161 statements.
161.
Yes.
Still, police statement. Normally it is.
The copy of the whole charge sheet. It encompasses of all the charge sheet.
Hmm.
Otherwise, I would seek time to maybe see the records or take a copy of the records. I feel in this case it will be important.
That will be available in record only. 161.
That is available in the record. I would like to see that.
Okay.
I would like to take a copy of that, in fact, because that won't be one page. If possible, if they could incorporate in the paper book, it would have been good. But otherwise, if they cannot, then I'll ask for a copy.
Okay. So.
Because sometimes.
See, then in that case, the paper book is again to be prepared.
That's what I was also thinking, yes.
Statement, but I have never seen 161 statement.
No, in some cases they do.
It is only the evidence.
Yes.
Evidence 164 statement.
Because sometimes what happens is that sometimes what happens is that there are some contradictions and everything which is mentioned in the thing. Yes. Since
161 to be incorporated in the.
Yes. In fact, I would. But if it is not possible, then at least I'll need some time. Yes.
Then in that case. Then only adjournment, seeking adjournment. Should I?
Yes.
Okay.
Lordship, in that case, just 2 or 3 days maybe adjournment. Otherwise, I've. If they, depending on how quick they give.
Okay. Miss Endang.
This coming Thursday, Lordship.
Some is that.
No, my Lordship, it's wrongly mentioned. I'm for the appellant, not amicus in this case.
Counsel for appellant. Some is that she is yet to go through the entire trial court record, including the police statement under 161 CRPC. Therefore, pray for adjournment of the matter for 2 weeks, 1 week.
No, my lord, it can be taken up on this Thursday.
This Thursday, no problem. Okay, as prayed for. List this matter. Thursday.
Yes, Lordship.
Record will go back today. It will go to the extent. I don't know if she will get the record.
Records, he just wanted to go through the 161 statement only from the record.
I have no issues. I was just pointing out. Maybe I don't know if she will get.
That is also there.
Because the record will be the steno today.
Next Thursday, then, Lordship.
Next Thursday. Okay, as prayed for. List this matter next Thursday. Mr. D.K. Pangu, Lan Amicus, and Miss Jeannie, Lan Edison PP are also present. Okay.
Obliged.
Item number 1.
Steps, no steps. No steps. Who is appearing for this step?
My lord, I'm appearing on behalf of respondent number 14 and 15.
None appears for the petition on call. Mr. Mr. M. Kato Leonard, DSGI is present. Next para. Office note indicates that office note dated 22/026/2026 reflects that no steps have been taken for service of notice upon respondent number 10 to 15. List of next para. MS, your name please.
Leroy.
MS
Yes.
Aero appears for enters appearance on behalf of respondent number 14 and 15.
14 and 15.
14 and 15. Next para. Petitioners to take steps for service of
2 weeks time may be given for
notice
final.
upon respondent number 10 to 13 within 3 working days. List after 4 weeks. We'll say 4 weeks.
Okay.
4 weeks.
Item number 3.
Well, this appeal is directed against the impugn order. Huh? Don't. Other side is. Mr. Tapak is not there, my lord, the HPCL council. There appears to be a letter of absence, my lord.
What to do?
Only, my lord, I am differing with 2 findings of the learned single judge. For that, my lord, under section 4, whether the circle officer is empowered to issue land possession certificate or not. The answer is yes. And here the learned single judge has recorded that it is only the deputy commissioner who can issue the LPC, my lord. That's the first thing. The second ground, my lord, which they say is that what to do, my lord?
You tell us what to do.
I was under the impression, because they did not call me yesterday, that then I started preparing the matter. The second ground is, my lord, they said that this LPC is not valid, but it is not the correct proposition of law. And there is a coordinate bench judgment, my lord, on the similarly situated judgment, where His Lordship Justice Mehdi has interfered with the rejection of the allocation of the petroleum petrol department, petrol outlet, my lord. So therefore, my lord is aware that National Insurance Company judgment, which says if the another coordinate bench have a differences of opinion, it would be better to refer to the larger bench. And without doing that, the earlier order is good or bad. If it is differentiable from the question of law on the fact and circumstances of the cases,
But
then
that
only he can.
That case was placed before the learned single judge.
I refer to that the single. My lord will find this which, Malal will kindly come that it starts from page 146 of the impugn order. Hey, Malad, I think if this matter can be adjourned in the interest of justice, the other side is not there. That will be their first ground to assail this order in the form of SLP. Malad. Take a date where we can have this. Huh? Next Tuesday. Eh? नहीं ये इसमें क्या नेक्स्ट ट्यूसडे कब है जून का तो वी आर टुडे नहीं 30 well kindly fix this matter for 30th minute. I'm aware of this. Para 19, my lord, I have placed this judgment and the learned single judge is recorded in para 19. Is 146.
This clause 46E requires that it should be there should be a certificate from the revenue officers,
correct,
confirming the status of the ownership, and it has to be submitted on or before 29/09/2023. Right. Learned single judge has not decided who is the authority to issue LPC or not. What the learned single judge has decided is, since you have submitted the certificate, whatever, LPC or whatever, land certificate, beyond the prescribed period.
No, but there is one communication.
Therefore, your certificate or LPC, which was issued on 23/12/23, is beyond after the last date of the submission. What is this 4
there is one communication.
Let us see.
There is one communication from there that after that was the last date, and thereafter they sent a communication to us in 24 that you are required to furnish the following documents.
You read.
I find out.
Para 25 communication.
Wait.
Para 25.
Para 25 of the impugned judgment, my lord.
Yes.
Wait, I will report it. Now, coming to the communication dated 13/6/2023 by which the petitioner was intimated was as regard his provisional selection, it is clear from the said letter that the certificate required to be produced should be issued on or before the date of application submitted by the petitioner, that it should be dated in hand. And LPC was admittedly issued by the revenue authorities on 23/12, well before the date, my lord. Well before the date, my lord.
Yes.
Which? 84? Yes. My lord will come to page 86. Page 86.
86.
Yeah. This certificate, it was before the last date of submission of the form, my lord. Land availability dated so and so. This is certified that land measuring 900 square meters so and so is available 16 so and so of 3 so Tabata gave. My case rests on this, my lord. And the
But-
section 4 and section 6.
You have submitted on the,
On date, not last date.
where is this 23/12/2023 LPC?
LPC. No. LPC. Yes, my lord, just I have noted it down. My lord will find it. No.
22 September
Okay.
2023.
LPC.
It is issued by revenue
I have noted
authority
down.
on
Sir.
23. How it is possible?
9/8, my lord. 9/8.
9/8. You have submitted this on after the communication to submit.
Yeah, they communicated to us, then we submitted this.
So how can
But-
you have this?
This is in support of the land availability certificate, my lord.
But earlier you have submitted 86.
Yes.
What is the discussion on that?
That in the impugn order, it is there.
Discussion on the submission of this page 86.
1 second. Para 18 meter. I remember it was in para 18. 1 second. Land possessions where I forgot to deal with applicable categories, so and so. Para 12. The Honorable Single Judge has recorded that para 11 and 12, Lord, thus a provisional selected candidate is to submit a certificate obtained from a revenue official confirming the status of ownership of the land as and when asked by the corporation. Here, in the case in hand, the authority by the impugn order has not raised any dispute as regards acceptability of land possession certificates as ownership document and the land availability certificate. The ground of rejection is that no LPC was available and the land availability certificate is not valid under Rule 143 of Arunachal Pradesh. But kindly see, there appears to be a contradiction in para 11 and 12.
No, there's no contradiction.
First, you have recorded that submitted a certificate obtained from
Obtained from the revenue office confirming status of the ownership of land as and when asked by the corporation, right?
Correct.
Then
Thereafter, see here in the case in hand, the authority by the impugned order has not raised any dispute. Once you have not raised any dispute, then the matter ends there, my lord.
you read further, the ground of rejection is that no LPC was issued available and availability certificate is
Not
valid
valid as per rule 143 of Arunachal Pradesh. So and so. So here I say, because in view of their communications, after provisionally selecting us, then we are asked to submit following documents. So accordingly, we have submitted the LPC. Now the question which they have, land available certificate, and then followed by the LPC to substantiate our bona fide that we are the owner of this land. Another question.
Let us the requirement close for.
Again, close for.
Page 52.
52.
52. 53.
53. Close for. 6.
Clause 6.
Clause 6. 4, 6.
No.
6.
4, 6.
Page 5. E is the most important at page 53, Lord. Any type of any.
Have you submitted this the page 56? Oh, sorry, 86 certificate?
Yes, before.
At the time of submission of application.
Correct, my lord. We have submitted.
900 square meters so is available at 16 kilometers near means Eastern Cross under so and so. Then what is this page? Other page?
Page 86.
86.
Then the other certificate?
LPC.
6.
96.
Yes, 98.
They wrote us.
This is something different.
Area same.
See,
same area, my lord.
No,
Same
no,
area.
land ability certificate. 900 square 30 and so is available at 16 kilometers near means Stone Crossing 14 under the so and then this is
87.
This is
4,275 described below so and so. Name of the area in which so.
Is more than the area zone in the land availability certificate. My lord will kindly flip back to page 87, where the map it has clearly been shown. Just take it out. And page 100 as well. 87 and 100.
Yes,
Same location in the LPC, additional land has been included. It's good for the company.
Where is the rejection?
Impure order rejection chronicle.
Section 91. 91.
Shield number 3, my lord. My lord, one thing kindly note, the date is 1st June 2024, and then LPC was 12/12/2023. LPC का निकाला 2003 का LPC. नहीं ये वाला LPC. हाँ. But only my concern would be serial number 3. However, it is observed that land documents submitted by you are not valid for considering the offered land under Group 1 for reasons as the LPC not available, land availability certificate.
Land cert is not valid.
Settlement
143.
Yes, but their requirement is. But
143.
143. Just take it.
Rule 143.
Rules, my lord.
I don't know why it is.
Page 26. 43. Well, I have only one copy.
You read it?
Yeah. 143, issue of certificate. The Deputy Commissioner may grant a certificate in respect of each holding to a landowner, certifying the nature of his title, the revenue payable, and the area, giving such other particular as he may consider necessary. Now, may not kindly see in the Principal Act, apart from Deputy Commissioner, the District Land Revenue Settlement Officer and the Circle Officer has been empowered. That's Section 4 of the Principal Act.
For issuance of?
Yes.
For issuance of
land possession certificate, declarations and all. Volume 7. All one.
Just that's one. This one. Rules. You just give the rule. Rule hai? Do you have the rule? Rules do you have? Rules do you have rules?
Once I supplied 2 copies of the rules here.
6 copy करना है section 6.
Section
6 4 6.
Yeah, 6 and this thing. 4 and 6. No, my lord may have the Principal Act, page 223 of volume 7. Six को निकालो.
6 15. 6
Yeah.
LPC and land certificate are 2 different things.
Here, in this case, they wanted us to show the ownership of the land. So therefore, my lord, Rule 143 has to be conjunctively read with Section 4 and 6 of the Principal Act. Now, Section 4, it says, appointment, according to them also, it should be issued by a revenue officer. Now, the Act says, Section 4, my lord, appointment of revenue officers. The government or such officer as may be authorized by the government in this behalf may appoint the following classes of revenue officers, namely revenue officer, revenue commissioner ex officio, deputy commissioner, additional deputy commissioner, director of settlement and land management, sub-divisional officer EAC, officers stroke EAC, now assistant commissioner, my lord. F is my case. It is issued by the circle officer.
Circle officer, which one?
4F,
Page 86.
223.
आपका रूल है सर जस्टिस का रूल
You have
No. My lord is, I'm
No,
reading,
I'm asking
my lord,
land availability certificate,
86.
page 86. Then
98 is LPC. Only to confirm my ownership that I possess this land. Otherwise, the requirement is only 98. No, I have. The only requirement is land available certificate issued by the revenue officer. I could demonstrate my bona fide ownership, my lord. Then section 6 of the Principal Act. The officers specified in terms D, F, H, and I of section 4 shall have power to take cognizance of all matters connected with the survey of the land and the settlement of the revenue rates and the preparation and maintenance of land records and other registers, and shall exercise all such powers and perform all such functions and perform all such duties as may be prescribed by or under this act or by a general or special order of the Gazette published in the officials. And my lord, the records which we are referring to, my lord, has rightly recorded by the Honorable Single Judge in paragraph 15 of the impugned judgment.
What does it say?
It says, admittedly, the petitioner, along with his application dated 22/9/2023, though submitted a land availability certificate issued by the Circle Officer Yazli, Lower Subansiri District, Arunachal Pradesh, but did not submit any ownership documents. That is LPC. Yeah. Just a copy. That is what? 145. I'll take it up. I'll take it up. Yeah, man. Then my submission was recorded at para 18, my lord.
What is the requirement?
Ownership only, my lord. Even the LPC is not a criteria.
It doesn't say. Just see. Requirement is
land available
among other Kharsa and Kathoni or any other 11 equivalent revenue documents or certificate obtained from revenue confirming the status of the ownership of the land.
Then correct, my lord. My page 86. It is issued by a circle officer mandated by section 4.
It's land availability certificate.
Correct, my lord. Only the confirmation as to whether there is the land is really owned by the applicant or not. It is or by means of lease agreement. There is nothing as such.
No, that's fine. बताए
Become better. Abhinay, this argument is going. May I request Lordships to have paragraph 18 and 19 of the impugned judgment, my lord. Para 20 is negating my argument, my lord. देखो एलपीसी का कौन सा एलपीसी डेट को निकालो तो नहीं
लेन नहीं it is report में submit on their
नहीं ये ask to submit by their lordships can have a bird's eye view on paragraph 23 of the impugned judgment as well.
So now the issue is on LPC,
On the
not the availability. Says page 56 is land availability certificate, which the learned single judge held that it is correct because there's no question of not, granted or issued by the
that is recorded in para 11.
authority competent.
Correct,
And
correct.
143 that has been
Para 11. Yes.
that has been accepted.
Now, my lord, the clarification is here.
That is accepted. The circular officer can issue. The issue is LPC. Now, LPC, the land has to be, according to learned single judge, it has to be, the certificate must be before the last date of,
No, my lord, that,
just wait,
Yes.
last date of submission of the application. Whereas your LPC is of 23rd 12. I think it's wrong. I think it's not 23rd. It should be 12/12.
12.
Right?
Right.
Clerical mistake.
That's why, my lord, the para 23, I requested their lordships to have a bird's eye view on this.
Huh?
Or I assist the court. my lord.
That I have seen your submission. It's your submission only. It's your submission only.
Correct, my lord.
So far as the issuance of certificate, availability certificate is not an issue now.
Not an issue, my lord.
I have agreed. Court has also
I
agreed.
qualified.
Learned single judge agreed. Issue is LPC.
LPC.
LPC, admittedly, you got it in after the issuance of, after the last date of the application.
But thereafter they
And you are supposed to have these documents on or before the last day of the application, submission of the application.
this is one count.
Prime facie appears, like single judge appears to be correct.
No,
So
but
what is settled, what you are not agreed, we will not go into that. 143, the grounds of rejection 143, rule 143 is accepted by the learned single judge. It is in your favor, right?
that's why, my lord, in paragraph 23.
There are two things.
Correct.
Rejection is on two grounds. One is non-availability of the LPC. Other one is issuance of the certificate by the under 143. 143 is gone. The single judge has accepted your argument. You are happy with that. The only issue is what is this requirement? It doesn't say specifically LPC. It talks about something. What do you call it? Harsa or something like that. Harsa.
That is, my lord,
So according to learned single judge, that this certificate, LPC or whatever, what do you call it? Harsa, Kachra or Katoni, or the equivalent document, which in this case is LPC, was issued beyond the last date of submission of the application. Because last date is 22/9/2023, and you have submitted this, of course, on their asking.
page 53. isko pakad.
When you are provisionally selected, you are asked to deposit, submit these documents.
Correct, my lord.
Kachra or something, Katoni, and in this case, LPC.
LPC, my lord.
And admittedly, you have submitted an LPC.
Not LPC. Land
LPC dated 23.
Lordship, in this case, Lordship, page 86 submitted.
We submitted page 86, land availability certificate, and that suffice. Therefore, my disagreement with the honorable single
Then
judge
you have to
was on this point.
read this clause 4(6)(e).
Ye wala na. E is justified in page 86.
Huh?
E, which my lord is referring to, page 86 justifies. The revenue officer has issued. Page kitne?
No, it's availability certificate.
Correct, my lord. Then let us read together page 53, my lord. E.
Read it.
As and when advised by. As and when advised by the OMC, the provisionally selected candidate should upload a copy of Kasra, Kathauni, or any other equivalent revenue document. What is this equivalent revenue document? Is page 86.
Complete.
Document or certificate, 53 years, or certificate obtained from revenue official confirming that the status of ownership of the land as on date of application. Even if, my lord, contra argument is that even if I would not have submitted LPC also, I fulfill the criteria in terms of this.
You could have submitted this. Why you?
That's why I'm not page
why you have
86.
submitted a different LPC.
LPC.
So the authority, the revenue documents, which is equivalent to Khachra or the Khatoni,
Yes.
is LPC. Therefore, you have submitted the LPC, which is of 23 or 12/12/2023, which is beyond the submission of last date of application.
Thereafter, kindly come to F as well. F, clause F. In addition to above, as and when advised by OMC, provisionally selected candidate under Group 1 should also upload a copy of any one of the following documents to establish ownership of land offered for the dealership. And that is LPC. And that is, they have requested on or before 23/12/2023, they should submit, they asked us to upload the document. So we have uploaded.
That was not the issue before the land single judge. You have not raised that issue.
No, but we categorically made a pleading, made an argument before the Honorable Single Judge that we have complied with.
It has been recorded.
Para 15. Para 15 of the impugned judgment. My lord. Page 145, my lord.
Petition along with submitted land availability certificate issued by the certificate insured. It's not a dispute.
That's why, my lord.
Did not submit any ownership document, LPC.
LPC, respectfully, we have not submitted on the last date of the submission of the application. But the requirement under the brochures and eligibility criteria is that we must submit one document certifying that the petitioner owns a land. And accordingly, page 86, we have done it, my lord. And then, my lord, kindly see, thereafter, let me complete this page. Page 53, my lord, if we can read together. Sorry to trouble their lordships. In addition to above, as and when advised by the OMC, provisionally selected candidates under Group 1 should also upload a copy of any of the following documents to establish ownership of land offered for the dealership. The document must have been executed, registered, issued on or before the date of applications. Register sale deed, register gift deed, register lease deed for a minimum period of 19 years and 11 months as advertised by the respective oil company. Any other type of documents, my lord, say. Any type of ownership stroke transfer deed.
So,
lease.
So the catch is, what is the catch? Before the date of application. You have to submit an application, the documents.
Kindly
maybe after after you are provisionally selected, the documents has to be before the.
I am foregoing the LPC
application.
Well, I am foregoing the LPC. The legal contention is page 86. Their gospel truth is overcome by me at page 86. They only wanted a certificate.
They say that the availability is not dispute. Although the respondent, no, London Single Judge has accepted that. The availability certificate, the circle officer can issue. No problem. That's why he did not, London Single Judge has not disagreed with the coordinate judgment of the coordinate bench. You are wrong initially. He agreed that circle officer can. Wherein the coordinate bench has said that it is the circle officer can do. That's why I did not. Although you are pressing, but I did not bother to look into this Land Settlement Act because I find that in the hindsight, I find that it was not required. So far as the case at the present case is concerned, right? So but now issue is whether under this E,
my lord,
E and F, the documents should be, you can submit documents on being provisionally selected. Which documents? The date of the documents is very relevant.
Date of recommend, that's why I'm not.
Because the catch is before the date of application.
Date of application, my lord, the Brownie point of law here is page 86. They require any documents to be issued by a revenue officer in terms of section 4 and section 6.
Then why?
Then there is no question of rejection.
No, it's not question of, you have been, on the basis of that documents, right? You have been you were provisionally selected.
Thereafter they have.
Now their requirement under E and F, you have to upload some or submit documents, LPC or whatever document.
My lord, kindly see the last date of uploading was 23/12/2022, 2023.
Not uploading.
No. Thereafter they are asked us to furnish the ownership land by on or before 23/12/2023.
Not to get the new documents and submit.
I have submitted
requirement is the documents which you may be submitted on 23.
Correct.
After the issuance of notice or ask you to submit, the documents, the date of documents is relevant.
I only can bow down what is falling from my lords because
no, and it's subject to what my
is the prerogative of their lordships. I can only assist as a senior court officer.
What my learned brother says, but this is primary passive. This is my prime view. No wrong, nothing wrong in learned single just.
No, but that's why I'm praising to the coordinate bench judge rendered by Lordship Mehdi. In this case also, LPC was submitted at later stage.
No, that was agreed. Learned single judge has not disagreed. Learned single judge has not disagreed. Rather, he has agreed. Therefore, there's no occasion to send it for refer it to larger bench.
No, but that's kindly see. But in any case, National Insurance Company.
That's why we did not. We proceeded to hear you, because if we have to, if you find.
That's why initially I pointed out.
If you don't, if you find no ground to interpret the learned single judge, why the response is not required to be heard. It is now you will have to, you are the appellant who has to approach the Supreme Court. What do you say? Just a minute.
No.
Just say this. It says, even subsequent cases that it should be honored with the last determination of the application. Or she will say no. Simply they say the correction.
That's what their letter says. Email, if you email communication email
but that letter say the guideline never said the documents were these must be before application. This is mentioned here.
Is before the
or before the acceptable. Yeah, or before the acceptable. Or before the last
rules name.
This year in the civil is out of office of the not waiting for
it is an impugn order.
उसको सबमिट करो नहीं होना एलपीसी एलपीसी नॉट एबल एलपीसी एलपीसी अवेलेबल इन इट्स नॉट वेरी प्रॉब्लम्स ये तो बहुत बड़ी चीज है इसे इनका तो
That's why, my lord, they kindly come to this page 91 for a moment.
91.
We read together the serial number 3. However, it is observed that land documents submitted by you are not valid for considering the offered land under Group 1 for reasons as detailed below. LPC not available. The requirement is we require to submit a land available certificate duly issued by a competent revenue officer. And that revenue officer, my lord, in terms of section 4F, the circle officer has issued.
Now, what they have interpreted as per the requirement of the clauses, the availability of the certificate is one thing.
And these are silent.
And the LPC is quite another thing.
My lord, kindly
Because
see their rules.
The Kachra and Katone is land documents. Availability is just a certificate. So you could have, suppose if you had the allotment order, that point of time, simply you had to submit that, which indicates that it was before the last date of submission of the application.
But then this is not mentioned.
Or you could have insisted that
my lord, in the
availability which is issued by the circle officer. But the appellant tries to be a little always smart. You obtain it, they ask you to, you obtain it, you forgot to go to the requirement. Of course, you don't expect that much of the
well, there is one English word, oblivious. The respondent authorities are also not oblivious to their process, their eligibility criteria, that they did not mention anything that one must have this document on or before submission of the last date of application.
Serial number, this 32 is, we're not discussing on it. All right, deliberation on it. Land ability, that is, a single judge has said, it is correct. Now LPC. Whether the LPC should be, the documents, the LPC should be honored before the last day or after, it can be after the last date of application.
But rejection on trivial grounds. This is a rejection on trivial grounds. The first criteria to meet up, to be selected for the outlet, is only as to whether the applicant has a land availability certificate or not. And this letter, impugned letter, 1st June 2024, my lord, then only this LPC was, the question of LPC was raised, my lord. It was not there before. Their rule is silent on this.
Instead of this LPC, page 98,
correct, my lord,
you could have submitted the page 86, that this is the certificate, which is equivalent to this revenue documents.
Therefore,
right,
therefore, my lord, for traversity of justice, a person should not be denied of his right.
But you have not been obliterated completely.
But conspicuous by their actions, my lord.
No, look at.
And see the conspicuous by their actions.
Where is that rejection?
They did not mention.
Where is the rejection?
91.
91. Has been found in, however, your candidacy can get considered for late selection along with Group T applicants as per guidelines. Not Group 1, but Group T you can be considered. That's why I'm saying, that's why I'm saying you have not been completely obliterated.
Therefore, my lord, the relief should be molded by pressing into the word equity. To do complete justice, this court has a power, because it is their misconstructions of the entire document and misreading of the entire document.
Are you saying that the land availability certificate and the LPC is one and same thing?
Same one.
Then why the revenue or the circular?
Therefore, it is their wrong interpretation. Therefore, my lord, they have appreciated and misinterpreted the entire documents. The first criteria you say that as to whether this person, the applicant has a valid land ownership documents or not, that I have qualified page 86. So only, my lord, I have to balance the equity and then do complete justice. Beyond that, I don't have anything to submit.
But basically, all has been done by the other respondent number 1 to 4, my lord. Only respondent number 1, Union of India, is the Papuma, my lord, the respondent, my lord. Everything has been done by the, my lord, the other respondent. However, my lord, there is a, my lord, one discrepancy in the corporation, my lord. In fact, if we see the, my lord, the guidelines, my lord, there is no mention, my lord, when always in, my lord, every such communication. 86.
Acha, one more thing. Where is the, just wait. Where is the communication by which you were directed to submit the documents?
Communication say, I have marked it.
It is page 9.
You know,
Directed to comment.
provisional selection ke baad because read petition में देखो. Evaluate notarized documents. There is one. Second kaka to ek to. No, there is one particular document I have also seen. Kaka to. एक था, there is one communication. Para 15 में recorded था क्या? Just एक से देखो था. 88. हाँ, नहीं यही है, इसी में है. No. Mirror page 89, there is one line which I find. After the box, para 1, 2, 3, please note that your candidature is liable to be cancelled in case initial security deposit or document listed above are not updated by 23/12/2023, my lord.
Yeah, what the requirement of submission of application?
I don't know, because it is their own volition, they wrote it.
No. Documents applicable for all category.
The page, annexure 6, page 88, my lord. Next, 89 is the... No, they have seen. You come next page. After thanking you, just second paragraph. Yes, correct. 89 में 2. No, यहाँ में. Karsa Khatoni equivalent certificate that we have done. And then kindly see, my lord, this last 2 paragraph. You know, 89. I remember. LPC is 12/12/2023, my lord.
That is recorded 23.
Yes. 12/12. Our LPC is 12/12. And they are asking us to submit the documents by 23/12/2023. We fulfilled, we met all the criteria.
No, that's the problem. These documents should be on the last date of submission.
Land availability we submitted.
Repeating.
That's why, my lord. There is a curation by the process.
You may submit by 23rd, 12th. No issue. But that documents should be, that of the documents, it should be before the last date of submission.
No,
Submission can be
86
afterwards.
No, my lord, page 86 is before.
No, they said it's a land availability certificate.
Huh.
The LPC, they consider it to be LPC to be a revenue document as required under E and F.
Right.
That is what.
Well, beyond this, I cannot impress the court.
Yes. No,
But
it's
only
question.
just I am assisting this from this particular page.
Delivering it. Yes. Yes, what?
Representation again.
We have filed the representation.
What was the result?
94. 94 is our, I think. 94 mil type copy. We have given the reasons here.
What was the result?
Result thereafter, no communications. Oh, communication, don't. There is no reply. There is no reply from them. My lord, may I request to indulge to last paragraph of the first page, 94, type copy. I'm reading out. In the dealership selection guideline of mentioned any documents, stroke type of documents to show ownership of land, and the provisional certificate dated 22/9/09/2020 covers this point, and this certificate dated 22/9/2023 has shown my ownership and possession offered land before submitting online application for the RO. Moreover, ADC actually has issued final so and so 12/12/2023 in my name in confirmation of earlier provisional certificate dated 22/9/2023, and same LPC has been enclosed with the application for your perusal and necessary action. And thereafter, there is no communication, because then thereafter we approached the Ladder Singh on this honorable court. We got the stay order, and then finally it was disposed of.
Actually, we according to us, you have the land, no doubt. But problem is more of a technical.
My lord, can we impress?
Practically and actually, you have the land. One is from the records. That's where certificate is been issued by circular officer. Then, but then.
Correct, my lord. My lord, it is not even a case of causes officers also.
We
You
cannot,
delete one person and are adding it. It is not that.
we cannot.
Because if I go by the causes officers
the
principles,
requirement of all these things, we cannot read in between the lines.
but my lord, that's why I was trying to find out that old judgment of our High Court, which we have contributed, which is followed by Supreme Court on the equity, my lord. The equity.
We have followed Supreme Court, or Supreme Court has followed us.
Supreme Court has followed us, which has been followed by Supreme Court.
Supreme Court cannot follow. We have
No. There's old judgment I remember, because they have described.
It might have been. It might have been flaws from here.
Correct.
But Supreme Court cannot follow us.
I bow down because there is a wrong selection of sentence and the words from my end. But then, my lord, kindly see, the word equity was drawn from the Chancery of England. From there it came that how proper justice should be done.
Not only word equity, almost all.
But
Rest we got it from the Gitas, Mahabharata, Qurans, and all this.
But this I don't want to go into, because this Plato was correct. Karl Marx was correct. If you want to destroy a nation, tell people to become a religious fundamentalist. That's all.
Sometimes
that is happening in a lighter vein.
We should be always cautious that we should not try to draw a long balls.
But my lord, it is my view that if a society
And they say,
then has to follow a constitution.
They say, you should not run with the hare and equally hunt with the hounds.
That's why I'm recalled to use the great phrases my lord used to refer in one of during the course of argument as a senior counsel. People across the board should not make a window shopping in the castle of Chinatown, my lord. That is what I remember. Anyway, it flows, my lord. Sometimes what happens, we as a human, we are born to err because our interpretations, our view are different. And then where we have to impose on the committee and omittee.
You should not exercise the power like a bull in China shop.
Oh, that's a between the lines. And I can say it's a candid stripe.
Of revisional jurisdiction.
Correct, correct. That's why it is in the line of candid
Not to
stripe.
exercise your power like a bull in the China shop.
Yeah, that's why it is in the candid stripe of between devil and deep blue sea. So therefore, from there where you have to draw a niche, and that
so for the
confluence
for the present context, Mr. Tara, let us not, run with the air and hunt with the hounds.
That my lord decide because like I cannot impose anything, and that is not within my bonds. That is not within.
That's all.
That's all, my lord.
We'll dispose it of.
That's a prerogative of my lord.
Although the respondent is not there.
But my lord will kindly balance the equity.
Oh, you have?
Because I have a physical possession of the land. That is the inference I can draw.
Yes, my learned brother has said that we should give the chance to other side.
Fine, my lord. That
in the meantime, you again ponder on the issue.
I'll lay my hands.
You may have some more, the acceptable points. Tomorrow we can take it up. Or day after. Thursday.
Yeah, Thursday.
Kindly, Mr. Tapak.
My lord, Thursday.
We'll dispose it on Thursday.
My lord, Thursday I have some difficulty.
We have, in fact, in that case, we have heard you.
No, but I'll come and clarify that point if, as to whether I can really convince this honorable court or not, because my duty is only persuasion and to convince the court only on a certain principle of law.
When do you want then? We don't want to carry. Give more because we have heard you enough. We have spent around 2 hours.
No, well, that's why initially I made a submission before this court.
No, it's okay. We have heard. We have understood what you have submitted. It's only to give a chance to other side.
Fine.
Only to hear them. That's why since we will be hearing him, in the meantime, if you have something more to argue, we're just giving
as a rejoinder.
Otherwise, it's not necessary.
Fine, Manoj. As a rejoinder, I shall try to.
We've heard enough.
Correct.
We'll keep it part heard. Day after tomorrow.
Thursday,
please ensure.
Subject to one condition.
Hardly it will take 10 minutes.
I have
not
two
more
matters.
Than 10 minutes.
I have two matters beyond this court. One
on Thursday.
One in principal bench and another in Meghalaya High Court.
Next Tuesday, but we'll keep it.
Next Tuesday, that's fine. That's next.
Part hard. Because we cannot, after hearing,
substantively,
so much of
correct
time, we cannot afford to.
Correct. Next Tuesday. Next.
Okay. Heard Mr. Titi Tara, Senior Counsel, assisted by Mr. G. Bablan, Counsel for the Appellant, and also heard Mr. M. Kanto, Learned DSJ. For respondent number 1.
Only one man.
We have heard the learned counsel appearing for the parties today at length. However, in view of however, since the Learned Council, Standing Council, Mr. T. Tapak.
My brother is appearing on behalf of
Okay.
T. Tapak is out of
You can argue also now.
Not
Anything.
He came,
Tuesday, we're not, will not adjourn. We're keeping it part hard.
Lordship, kindly this matter maybe fix another date.
Tuesday.
Yes, Lordship.
That's what I'm saying.
yeah, Tuesday, my lord, fine.
Yes, Lordship.
I said
No,
also,
inform.
No, please do. How about in view of the prayer of Mr. S. Irang,
B. Sibo.
B. Sibo, Learned Council appearing on behalf of Mr. T. Tapak, Learned Council. Standing Council for what? Respondent number?
SPCL, respondent number 2, 3, and 4.
2, 3, and 4. On the ground that Mr. Tapak has some personal difficulty, come up. Let this matter be listed.
next Tuesday,
on Tuesday is what?
30.
30. 06/2026 as part hard. No, 6, please step, huh? Better remains part hard.
Grateful.
Item number 7.
Please, my lord. My lord, this is an appeal against conviction under 302 of the IPC, my lord. But my lord, after going through
Before any other appropriate bench, without one of us, huh? Justice.
but I can be fixed on 27, my lord.
We cannot.
Obliged, grateful.
Item number 8.
Yes, and my lord.
Ah.
Here, my lord, I am playing some more time, my lord, to file my
5, 6,
affidavit.
7.
My lord,
5, 6, 7.
my lord.
Non appears for the petitioner.
Last occasion also petitioner was not.
We'll see. What is the issue?
This is allegation regarding construction of roads.
Construction. PMJSY.
PMS.
You are for?
Private respondent, my lord.
Contractor.
5, 6, 7. my lord.
We'll see on next day. All right. Non appears for the petitioner on phone. As spread for by Mr. L. Lanet Council for the respond numbers 5 and 6, 5, 6, and 7. Further 3 weeks time is granted to file affidavit of Mr. G. Tarak Lanet, Standing Council, RWD, is present. You have filed the affidavit.
I am not yet.
Then in that case, as spread for by Lanet Council, put their names, huh? For respond number.
They have sought for
Standing
investigation.
Council, Standing Council, RWD and Mr. L. Permel and Council for 5, 6, and 7. Huh? But the 3 weeks time is granted to file affidavit.
Oh, obviously.
Item number 9.
Before the friend starts, your lordship knows the work has been terminated. And on the last occasion, your lordship in fact granted 4 weeks time for resumption of the work. They have filed an affidavit saying all sorts of things. The common public is not cannot be bothered with that. They will have to fix with the contractor, the earlier contractor. What I find now is they have now issued a NIT at 971 of their affidavit. It's an additional affidavit. They have now issued a NIT with an estimated cost of 5.27 crores for maintenance work for a period of 1 year. What about the main work? And what maintenance of what? There is nothing left to maintain.
971.
The primary work has to be resumed. Some steps has to be taken for that. Short-term maintenance contract, estimated cost 5.27 crore. Period, contract duration 12 months.
Okay. What if the
What is this? Yes.
What the procedure is, after the termination,
the site verification has to be done, whereby the completed works and the uncompleted works have to be measured, jointly measured. This has been done now. Ending and taking over has also been done. Now, the authority has to send it for de-sanctioning of the earlier work, earlier project, my lord, so that a fresh sanction has to be obtained. So that will take some time. What I'm told, the procedure.
That's why we have under the, I mean, with an expectation that they will
Yes,
complete all
yes.
this. We're not saying that you cannot, don't have to
That's
go on
why
this thing.
in the meantime, because of the dilapidated road condition, this short-term maintenance, at least for the smooth flow of the traffic, this to maintain the road, that has been. Otherwise, that for completion of the project, we are expediting the procedure, official procedure.
So,
My lord, I was
how long?
submitting.
How long it will take?
My lord, from what I have understood is, what my learned friend just told me, that the central government will now have to de-sanction it.
Yes.
And thereafter issue fresh sanction
For the remaining work.
Now, my learned friend representing the union government, now it appears the ball is in the union government's court. My learned friend is not here today. Can the representative of the MORT be directed to be present next week? And thereafter some positive directions from your lordships? Maybe he will at least
To
tell
expedite
What is
the
this?
official process.
DSJ?
But this is the official
What is
process.
the stage? I mean, have you already processed?
No, my lord, now after all these measurements and all, we have submitted to the authorities now. And
MORT.
Now they will have to de-sanction it.
No, we have understood. Where it said because of the unfortunately development.
Yes, yes.
It has to be terminated.
Yes,
we cannot,
yes.
I mean, we
Yes.
cannot say that you should not do that. Process takes time.
That I understand.
It has to be expedited.
If it is
We're not
expedited,
saying
then
that.
at
And it's
least
good that they are also, concerned about the maintenance also.
yes, yes.
So it's good. Then we'll fix it on next week. We'll take it up.
Yes.
Yes.
We'll
At least
pass
some
the
instructions
orders
from the
on-
central
on-
government, yes.
MORT.
Yes.
Okay, heard,
Because at
Mr.
least the next working season may not be lost.
Yes, yes. Before all the official procedures may be completed, all tenders may be completed before the next working season.
DAJ.
Lordship, due to some urgency, he left the court.
Okay. Heard Mr. Deepang, learned senior counsel, assisted by Mr. M. Doji, learned counsel for the petitioners. And also heard Mr. Anderton, learned additional advocate for the state respondents. Expert. Having considered having considered the submissions of the learned counsel for the parties as regards certain developments of the issue. Come on. Whereof we deem it appropriate to direct the representative of the
Regional officer, MORTH,
regional
Tezpur.
officer of the MORTH
Tezpur.
Tezpur.
Yes.
Yes,
Yes.
my lord may direct indicate the RO.
Regional
more.
officer.
Yes, based at Tezpur.
Not the representative.
We deem it appropriate to direct the regional officer,
Yes.
MORT, Tezpur, to appear before this court. Accordingly, it is directed that the regional officer, MORT, Tezpur, to appear on when?
Tuesday.
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 on 3803. Will it not be too short a notice?
Tezpur, my lord, my learned friend, Mr. Kato can do the needful.
0620, next pair. Learned Council, Mr. M. Kato, learned DAJ to appraise this order. No, and I will say is requested to inform the regional officer. Mort. No. Next pair. List accordingly. Huh?
Obligement.
You just inform Mr. Kato.
Yes, I will also tell him.
Yes.
Yes, I will.
Because it's the interest of the public.
Yes, yes.
So we're not calling him for anything else, but then to deliberate what is the way out.
Yes, exactly.
Item number 11 and 12.
Yes.
Your Lordship, I would like to withdraw this and refile it, Your Lordship. So I may be given liberty.
Which one? Both?
No, Your Lordship. Item number 11, Your Lordship.
11.
11.
Mr.
P. Wangpan, Your Lordship.
Huh?
P. Wangpan.
Item 11.
Yes, Your Lordship. I will refile it, Your Lordship.
P. Wangpan, learned counsel for the petition. Press for withdrawal of the public interest litigation.
Your Lordship, I will refile it, Your Lordship. Actually, this.
Liberty to file a press. What to do? Huh? MS, press and according to the writ petition, public interest stands closed on withdrawal with the liberty as spread. Normally, it's a public interest litigation. We just cannot casually.
No, actually, Your Lordship, what happened? This was filed as a WPC, Your Lordship.
Then you just record a MS. P. Pangulan State Council is present. Yes, next.
Much obliged.
Then PI 15.
Yes, Lordship, this is same matter, Lordship. So this has
You
withdrawn.
want to also withdraw?
No, Lordship. I'm
Then?
going to return. No, Lordship, this inform everyone.
Item 15.
What's item? What's item?
What is to be done today?
12.
Oh,
Affidavit.
Yes,
File the
yes,
affidavit.
we have filed, Your Lordship.
Who has done? Respond 3 and 4.
Yes, for respondent number
3 and 4. Who is 3 and 4?
1, we have filed, Your Lordship.
Lordship, 3 and 4, do you have standing counsel, your own standing counsel?
Who is there?
Director of
Mr. G. Kato, learned counsel for the petitioner. MS. P. Pangut, learned state counsel, semester. She has already filed affidavit in opposition on behalf of the state respondents. Next para. None appears for the respondent number 2, 3 and 4.
Yes, Lordship.
Mr. Howard. List the matter, not however, list the matter after 3 weeks, 4 weeks. In the meantime, respondents may file respective affidavits.
Obliged, Your Lordship.
Item number 13 to 15.
May I please, my lord? My lord, I am legal aid counsel for the appellant. In item number
Here does it learned LSC to the appellant. In all the cases,
Yes, connected, Lordship.
all are connected. Yes, arising out of same.
and also and Mr. D. Loy, learned public prosecutor for the state. Since the paper book has already been prepared and furnished to the respective learned counsel, let this matter be listed for hearing. After
Break, Lordship. Summer break.
after 4 weeks.
Yes, ma'am.
These appeals listed for hearing.
Item number 16.
No. 13 to 16, 13 to 15.
16 is different matter, man.
16 is separate, Lordship.
Acha.
16 is separate.
15 is for what?
My lord, on last occasion, my lord, the registry was directed to furnish the record to the council, the legal aid council, Mr. Legam Nasi. But on last occasion also he has taken time, my lord. But now on last occasion the TCR was not received. Now it's received now, my lord. So let the record be furnished to the concerned council, my lord, and file the appropriate application accordingly, my lord.
Application for?
My lord, there is a delay of
No,
1,000.
That has been already received.
We have not received any copy from
Received trial court judgment on behalf of LNOC.
trial court.
Judgment he has already received.
Yes, my lord. Judgment he has received, my lord, but he has not made any application, my lord. So far as for condoning the 13. He is not present today, man.
Okay, had Mr. T at learned additional PT. Next para. The Mr. LNOC.
LNOC, yes.
Legal aid counsel to file an appropriate application. Is directed to file an, which is directed?
It was not directed, my lord. Now, my lord, on last occasion, my lord, registry was directed to furnish all the record. And it was also pointed out there was delay, my lord. So for that, my lord, he has to make an appropriate application, my lord. And if required, my lord, appeal, memorandum appeal also.
We'll say in that case, Mr. LNOC, then you say had Mr. T at learned public prosecutor. Mr. LNOC, learned additional, learned LSE. Is not present, Mr. The registry to furnish the
Record, my lord. Yes, ma'am.
learned
Trial court record.
LSE, record of trial court to learned NSC, Mr. LNOC. Next para. As observed earlier, Mr. LNOC to file an appropriate application for condemnation of delay in filing the present appeal within 1 week.
Yes, my lord, within a week. I will inform the
This is the matter of
legal aid council, man.
2 weeks.
Obliged, ma'am.
Inform him.
Yes, yes.
Item,
Yes, yes. No, memo is also not there, my lord.
Convenience as well as memo of appeal.
Yes. Obliged, man. I will inform him.
item number 17.
Now it appears for the appellant on call, Mr. Office note dated 22/06/26 reflects that neither the editor nor unserved notice has been received by this company. The respondent list in view of that list the matter after 4 weeks. 4 weeks, right?
Item number 20. Here, Lordship, IA was disposed of, IA already disposed of, Lordship. Today, Lordship, the Tisha has not called for yet, Lordship.
Okay. None appears for the appellant on call. Our MS L. Hage learner additional PP is present. List. Admission. This for admission. This for admission after 3 weeks.
All right. Item number 23.
May I please your lordship? This matter, lordship.
Yes.
We have received paper books, lordship. I'll pass.
On the when we'll give the fixed date in the
Next Tuesday, lordship. Next Tuesday.
It's fine. No problem. Tuesday, next Thursday.
Make it next Thursday.
All right, lordship.
Next Thursday, Tuesday, we have.
All right.
On the prayer of Mr. J. Learned Counsel for the appellant, let this matter be listed on next Thursday is when? Second 02/07/2026. MS J. Learned Addition PP is present.
Wait, please.
Yes.
Well, back to mention item number 4. Matter pertains to district-wise reservation. Your lordship, while on this side, had appeared in the case of Nyayam Loy. Exact similar. Same.
Okay.
Not in this case, but there was another writ petition.
Is there bar?
I'm just pointing out, my lord.
That was disposed of.
No, that was not disposed of. That was withdrawn.
Okay. Okay, it doesn't look nice. But it's an interesting matter. Okay. List this matter before any other appropriate bench without me.
My lordship, I beg to item number 6.
6.
On behalf of Dita Box. Letter may be listed after 3 weeks.
Why?
Leading counsel is out of session.
The matter about?
A matter about allotment, cancellation of allotment.
Cancellation and allotment.
Yes, lordship.
Okay. On the prayer of Mr. S. Sibo.
BC.
Learned Counsel appearing on behalf of Mr. T. Tapur. Learned Counsel for the petitioner. Let this matter be listed after 6 weeks.
3 weeks.
3 weeks.
Item number 1.
My places, my lord.
Yes.
My lord, Kevit was discharged already yesterday.
Not yes, discharged.
Oh, discharged. Kevit,
Mr.
Kevit.
Better. P. Tapo, Learned Counsel for the. That is senior counsel for the Kevit. Kevit is still discharged.
Well, the case fact in nutshell is that.
Come to the impugned judgment.
Impugned judgment. Correct.
Disqualification.
Correct.
Page 42.
Correct. Then
what is the ground?
The
disqualification.
Disqualification, my lord.
You have admitted.
No, but admission is one thing, my lord. The procedural aspect is another thing, my lord. You issue a notice of hearing on 22nd, and then on the same day you hear the matter. When the counsel for the petitioner who appears before the London Deputy Commissioner prays for adjournment of the time.
It's not recorded.
It's not recorded.
It's just the respondent through London Council admitted that she had cast her vote in favor of the BJP GPC candidate.
Correct, my lord.
And in view of the amended provision, once you are admitted, and you have acted against the
That
whip,
is,
party whip.
no, my lord, that is another thing.
Okay.
The appreciation will be on the 2 points, my lord.
Ah.
I'll just, before this, I'll take lordship to one particular page. Kindly come to page 39. 38, my lord. This is the latter submission by this one Neelam Sanjay, who purported to be the chairman of Disciplinary Action Committee. My lord, on the top, we'll see 301/2026.
Page 38.
38, my lord. 39.
39.
How the process of disqualification has started, my lord.
39.
301/2026.
So it has to be forward within 30 days.
24 days, my lord.
24 days.
Yes.
Number one.
48 hours.
48, sorry, 48 hours.
Yes.
And it's the
Then 30 days.
30 days
has
to be disposed of.
To be disposed.
Where's the provision?
My lord, before this, kindly have this look. Have a look this. Why there is a fraud
No,
in this?
this was forwarded on 3/1.
My lord, kindly.
2026.
No, my lord, may I request only to see this paper? I am pointing out certain interpolations in the document itself, my lord. 39, my lord. 3, for date, my lord will say 3/01/26 on the top. Then, my lord, kindly come to the bottom. Then see, the receipt date is, my lord, 2339, and date of receipt is shown on 03/02/26.
Page 39.
39, my lord.
Hmm.
2339, and my lord, receipt number, date number is 03/02/26. And when it was signed, my lord, 3/01/26. There is a complete fraud. How this document has been interpolated, my lord. Date. Now here comes the procedural, not even aberration, my lord. Then what happens is, to cover up, my lord, now my lord will calculate one thing. Kindly see the date of, no, my lord.
Signature, just one by one. Signature is of 03/01/2026. And
date of application is 03/01/26. Kindly note this. The member secretary slept over for many days.
So you are counting from 01/0.
Correct.
03/01.
Correct, my lord.
Then.
And these documents are obtained through RTI, my lord.
Whatever, maybe we'll
I'm coming to that.
Go by the receipt.
No, my lord, it cannot be. It cannot be backdated. The day application is submitted, it should be on that date only.
No, it's not possible.
No, my lord. This cannot be allowed to flood.
See, date of submission of the application will be the issue.
No, but then, my lord, kindly see.
Not the signature.
What is the no, my lord. No, it's not. It is not the case. This is much afterthought.
No, see, receipt is shown to be 03/02. Signature, that's okay, 01.
No, that's why, my lord. What is the requirement? You cannot do this way. If you are to disqualify somebody by means of writing, it should be submitted on the same day.
Okay.
You cannot keep these documents like this.
We'll examine that.
Yes, my lord. Then secondly, my lord, kindly come. My lord, kindly come the impugn order. Then I am coming to the impugn. Then, my lord, what will happen is
the substance.
The forwarding.
Technical, we'll see.
Yes. My lord, the forwarding. I'm showing that how the entire proceeding is vitiated.
So let us assume that this is of 03/01/2026.
Correct.
When it was forwarded?
On 03/02/2026. And on the 4th, the deputy commissioner receives it.
Otherwise, if it is of 03/02, it's within time. All right.
Yeah, within time.
We'll examine.
That is within
Okay.
time, my lord.
So according to,
then-
since the application
Yes.
of 03/01/2026,
Correct.
it is beyond 48 hours.
Then beyond 48. And the date of forwarding, it is shown as 4th. My lord will come to page 40.
Huh.
Then my lord can count well 45 days slept over. And then 4th February 2026.
Forwarding.
Yes.
And the order is of?
Order is, the complaint was on 03/01/2026. Then the receipt was shown on 03/02/2026 in order to fill up the mandatory provisions, meet the requirement provisions, and that is page 40, my lord. The forwarding was done.
Yes, what's the provision?
My lord, before this, my lord, I'll satisfy my lord to that extent.
Issue notice what taking
No, my lord. Kindly see. My lord, kindly, one document in the,
why they are saying that what's the provision that it should be forwarded within 48 hours and then decided within the 30 days? Let us see that.
Yes.
We'll go by the substance. Technicalities will see.
Correct. Where is that? Disqualifications. Then only I'll come to the impugn. May not have this manual?
We have the manual.
Already there.
Arunachal Pradesh. It is the latest one.
Yes.
Yes.
Six, 1 and 2, my lord. Let us read.
Page
166. Last few. A complaint that a member has become subject to disqualification under Section 3 may be made by a member or a political party to the member secretary of the concerned local authority. In a case falling under Clause A of subsection 1, after the member gives up the membership of the political party. B, in a case falling under B of subsection 1 after expiry of 15 days. In a case falling under subsection 2 after he joins the political party. Here it is not a case of joining, my lord. It is violation of the whip. Purported violation of the whip. Purported violation of the whip. Number 2, where a complaint under subsection 1 is received by the member secretary of the concerned local authority, he shall within 24 hours from the receipt of such complaint refer the same for decision to the State Election Commissioner. That has been modified in 2006, substituted. Who shall decide the question within 30 days after receipt by him of the reference, and his decision shall be final. Now, my lord, this law where it is conflicting, I will show from the impugn order. Let us admission and this part, these are subject matter of the adjudication, my lord. Kindly come to the impugn order. My lord, come straight to the page 45. Finding number 3. Page 45, my lord.
Yes, read it.
Well, just there is a small technical grease in.
Yes.
Number 3, my lord, page 45. Findings.
It's a directory.
Direct.
According to the Deputy Commissioner.
Yes.
Okay.
Whether this authority, because this was raised by the counsel for the petitioner who represented, whether this authority's jurisdiction is extinguished after 30 days period under section 2, subsection 2. The 30 days period prescribed under section 2, subsection 2 of this act is a directory provision intended to ensure expeditious disposal of defection. It does not operate as jurisdictional bar or a period of limitation. The authority's power to adjudicate derives from the statute itself and is not extinguished by mere passage of 30 days. The Limitation Act 19, my lord will mark this. The Limitation Act 1963 has no application to these proceedings as the principal act contains no clause that attracts. It should this authority fail to decide within 30 days, the aggrieved party's remedy is to approach the Honorable High Court of Arunachal Pradesh under Article 226 of the Constitution of India for a writ of mandamus. This is Kobe-Etes judgment. Law of limitation falls. The statute provides you to decide this matter within 30 days. You have failed to do, and you are going against the decision of this court, this Kobe-Etes judgment. At Jumar Bagra judgment, this law of limitation will be applicable here, my lord.
In the Defection Act?
Yes, this is interpreting, my lord, interpreting the AFR, a special act of the state. There, H.N. Justice, then His Lordship H.N. Sharma, have interpreted Section 29 of the Limitation Act. And it says it will be applicable in all the special statute. And subsequently, by another decision of this Honorable Court, in Jumar Bagra case, 2016, rendered by Her Ladyship Indrasa. Where is that? Another one? Give me both. This is the end of matter.
See, when you say that the Limitation Act doesn't apply, it equally, I mean, it doesn't mean that it is...
No, my lord. What is law? This has to be followed.
What is
that
the
would
law?
be my respectful submission. The law says any special statute enacted by the law, enacted by the state, it will be applicable, my lord.
Where is?
Para 12 to 15 in... my lord will see this. My lord, better to have this Karjum Basar, paragraph 15. It has recorded, reproduced everything.
Which matter? Which case?
This is civil revision, my lord, number 26.
No, which one?
Jumar Basar, Karjum Basar.
Okay.
This was a case where interpretation was made whether the law of limitation will be applicable to AFR or not, in terms of limitation provided under Section 50 at that relevant point of time. My lord will kindly come from para 14, next page. Here, Kobe-Etes judgment is also relied on. Thus, Section 52 expressly provides 1. High Court, 2. Deputy Commissioner, and 3. Assistant Deputy Commissioner shall be guided by a spirit of Civil Procedure Code and principles of Limitation Act only in case of dispute between persons who are not indigenous to the state of Arunachal Pradesh. Subs Clause 2 of Section 229 of Limitation Act read as, where any special or local law prescribe for any suit, appeal, or application a period of limitation different from the period prescribed by the schedule, the provisions of Section 3 shall apply as if period were the period prescribed by the schedule, and for the purpose of determination, any period of limitation prescribed for any suit, appeal, or application by any special or local law, the provision, my lord will mark this, any special or local law. This is a Panchayati Raj Act enacted, the defection rule is framed by state government, it comes under this. Local law, only insofar as and to the extent to which they are not expressly excluded by such special or local law. In the cited case of Kobe-Etes versus State of Arunachal Pradesh, here Lordship Tagya was the counsel. Reported in 2005 supplementary GLT 626, there was delay of 41 days in filing the civil revision petition, and application for condonation of delay was moved. This court held as, now, having satisfied the requirement of Section 29(2) of the Limitation Act so far, the provisions regarding the local law or special law is concerned, we are to see at this stage whether Section 52 of the 1945 regulation can be interpreted to exclude the provision of Section 4 to 24 of Limitation Act 1963 in the context of the said 1945 regulations. On a bare reading of Section 29(2) shows that such exclusion is permissible so far as and the extent to which they are not expressly excluded by the special or local law. Section 52 of the 1945 regulation incorporates specific provisions regarding applicability of the principle of Limitation Act. So for the person who are not indigenous to the present state of Arunachal Pradesh, it has not provided expressly about the applicability or non-applicability of the provisions of Limitation Act. Similarly is the case, Miller, here. So far, the indigenous persons are concerned, and Section 52 is silent about it. On the other hand, as discussed herein, above the scheme of 1945 regulations exclude the applicability of the provisions of limitation altogether. Section 29 of the Limitation Act clearly indicates that such a special or local law must provide the period of limitation. Under such a special or local law must provide the period for limitation as contained in Section 4 to 24 inclusive as found in the Limitation Act shall apply. Section 29(2) gets attracted for computing the period of limitation for any suit, appeal, or application to be filed before authorities under a special or local law. If the authorities' conditions laid down therein are satisfied, and once they get satisfied, the provisions contained in Section 4 to 24 of the Limitation Act shall apply to such proceedings, which obviously means that procedural scheme contemplated by these sections of the Limitation Act would be applicable in case of filings of appeal revision under the provisions of special or local law. Turning to paragraph 13. Turning to expression expressly excluded in Section 29(2) of the Limitation Act, the said expression is clearly demonstrative. It signifies exclusion by once. It will not mean exclusion by a process of construction or by reasoning. If we are to exclude the provisions of applicability of principles of Indian Limitation Act, then we are to go for reasoning to extend that as the said Section 52 makes the provisions of applicability of Limitation Act. So for the persons who are not indigenous to the state of Arunachal Pradesh. Therefore, the person who are indigenous to the state of Arunachal Pradesh are excluded. Such construction will go against the provision of expressly excluded. The law is settled. And here in Kuwait case, my lord, already it was held. It will be applicable.
Sir, let us remind ourselves, the limitation applies to what? To approach the authority or the forum, right? Limitation provides.
Correct.
The elementary thing. Here you are assailing that under the specific provision of act, the authority has to act within a particular period.
Correct.
Which they have well to do it. That would be completely different thing while trying to interpret this judgment in the Limitation Act. And that to this judgment is rendered on a situation taking into account of the Regulation 52 and 29 of the Limitation Act.
Regulation is
so far as the law to file a revision petition before the High Court or any other forum. All right. So this cannot be mixed up. We understand whether it's a mandatory or directory, and whatever the authority has said, so we cannot say blindly said it's correct. We'll examine it. We'll issue notice.
No, my lord, kindly
but the substance is that except you may be correct in it should be within the particular period as provided in Section 2, right? 6(2).
Correct.
Either both the providing as well as the decision within 30 days.
Within 30 days.
Now, that is something we'll examine it. Today we cannot settle that.
No, my lord, kindly see that.
But the substance on the face of the record is that there is a ground, appears to be a ground for disqualification, as you have admitted that you have voted against the whiff.
Admission, my lord, that is subject.
Let us see
that is a disputed question of fact. My lord, that is a dispute.
On what ground you can be disqualified? Let us see that.
Then, my lord, one minute for that moment.
Yes.
Now, we.
See, I
My
don't know what is the ground for disqualification under the
My
law.
lord,
Let us see.
Kindly,
Please come.
afford me 2 minutes. I'll make one submission on this. When, my lord will.
It's 30 minutes.
My lord, recall this Singara Singh judgment, 1964, referring to Taylor versus Taylor judgment.
Right, that Singara Singh?
I'll provide this. I have.
Singara Singh versus?
Where in this case, my lord, where I will provide this copy, my lord. Paragraph 8, wherein it was held that where a power is given to do a certain thing in certain way, the thing must be done in that way or not at all, and other methods of performance are necessarily forbidden. When the statute mandates you that you must perform your duty within a period of 30 days, you cannot travel beyond the settled proposition of law. The second thing this is on the first query that has fallen from Lordship. So therefore, the Deputy Commissioner has acted beyond the scope and ambit of the Act that has provided under subsection 2, section 6 of the Act. So therefore, my lord, the interferences must, and the reasons, my lord, every judgment I don't comment upon, because every judgment, the person who is the author of the judgments always give a reasons. But that reasons has to be dissected by the court, whether his reason is impregnated with rational nexus or not, my lord. Therefore, necessity of giving reasons. She has given the reasons in para 3 of her finding. So therefore, you cannot travel beyond this, my lord. When, my lord, this issue was raised by the learned counsel who represented before her, then my lord will very well see this Ravi S. Naik case, my lord. Now, natural justice has been violated. Law says you should give adequate opportunity. This is a predetermined decision, my lord. This cannot be allowed, my lord.
Notice was issued to you?
Kindly see, notice was issued to me, fixing a date of hearing on the same day, my lord. This was disposed of. The order was written down, my lord. Is this permissible, my lord? At least the procedural law you have to follow.
22nd April. And it was 28 May.
20, it was, the judgment was delivered on 20th of May.
Hard on when?
Hard on, just for a moment. 4-5 it was heard. But just I provide. My lord, kindly see page 41. Kindly come to page 41. 41 is the type. 40, 41. 22nd April, I remember. 22nd April 2026. Hearing was fixed on 4th May. Page 41.
Same day.
That's why, my lord, kindly see. Kindly see this on first notice
After
for hearing.
12 days.
After 12 days, my lord, I appreciate, my lord. Then kindly come the impugn order. The impugn order, my lord, kindly come. The established fact, my lord, page 43, my lord, kindly come. No, 44. 44, my lord, 44. Serial number 12. On 4/5/2026, both parties were present and were fully heard. Learned counsel so-and-so appeared for the complainant petitioner. Learned so-and-so appeared for the respondent. Yes.
Yes. It's 1 o'clock. Yes.
So, my lord, serious apart, my lord. In this Kobe, where Lordship Nani appeared, he lost the case. And in Jubal Bazar, Mr. Ratan was there in this case. So now, like, coming to the point, my lord. Now, what I say is, my lord, when law says you have to do things in a particular manner, in your Singara Singh case, my lord. Yes. नहीं वो भी है but Singara Singh is 1964 में para 8 में that Taylor and Taylor is reiterated that is the leading case and then the statute provides you to perform certain duty in a particular manner you have to perform in that particular manner only my lord. So here my lord why I am saying is now the deputy commissioner has taken up the matter after expiry of 89 days window my lord. Now suppose my lord 30 days adjudication window was likewise extinguished. Well, in as much as, my lord, upon receiving the respondent number 2, my lord, the member secretary who has forwarded that complaint, he was bound to dispose of this matter within a period of 30 days as prescribed under subsection 2, section 6 of the Defection Act, Local Defection Act, my lord. Now, here what had happened, the respondent number 2, my lord, has set on the matter for 89 days, my lord. 89 days, even before scheduling a final hearing on 4/5/2026. Then ultimately, my lord, the impugn order was passed on 28/5/2026. Now, my lord, I have quoted this in ground number 5 of my read petition, my lord. There are later decisions also, my lord, that on this proposition.
No, it's come back to the question again that whether the provision is a directory or mandatory.
It is mandatory.
How?
It is mandatory because the legislature with their utmost wisdom has framed this rule that this particular thing has to be dealt in this particular manner, fixing a time limit, my lord. So now, my lord, kindly see.
Suppose RP Act. So supposed to be disposed of within 6 months.
I am aware. I am aware. I am aware of this.
But I may agree with so far as the principle of natural justice is concerned.
Correct.
But rest as of now.
I'm coming to that. I'm coming to that also.
Not
I have
relaxed.
another.
So we'll issue notice.
Another 2 grounds because I'm pressing.
See, today is Mosul.
My lord, please, my lord, kindly afford me. With these days, clients are also watching.
We're not concerned.
Whether
we're here not to
now, my lord,
not to display ourselves.
Correct, my lord. Even then, now, my lord, after expiry of
render justice.
Let me come to the legal point, my lord. Now, my lord, what had happened? After expiry of 89 days, he has become functus officio and having a quorum non judice. A person who is authorized by the law to do things in a 30 days, and he takes up after expiry of 89 days, he has become quorum non judice in view of the.
So that's why I agree.
That is what
it may be a debatable issue. We'll deliberate on that.
No, but I am coming there.
Yes.
Now, my lord, see, Rajendra Singh Rana case, my lord is aware.
We'll have to hear them and we'll give them an opportunity.
Correct, my lord.
As you have not been,
2 more ground, my lord.
Been given.
Well, 2 more ground, my lord. Whether my lord give me reliefs or not, that is immaterial to me.
Don't.
That is another thing.
Don't blush out everything.
No. Let me blush out. That is fine.
Keep something.
Fairness. Everything is fair in love and war, my lord. Let me allow to do this.
Unfortunately, neither we are in law but nor war.
There is no war in law.
War in
Mental war.
Process.
See, my lord, kindly see.
So there may be unfair.
Yes. My lord, kindly.
Neither we are in love nor in war.
Correct. We are in committee. My lord, please, I am making an interim prayer. Only.
Yes, I'll consider your interim prayer.
5 minutes, my lord. 5 minutes. Give me 5 minutes. I'll conclude this. Because, my lord, I said ki quorum non judice, he cannot take up this matter.
Take it note.
Okay, take it note.
Then.
Second thing, my lord, is aware. Section 6, subsection 2 of this Disqualification Act is pari materia to section 6, 1 of the 10th schedule of the Constitution of India. Now, what it says, while a deputy commissioner in the 10th schedule, my lord, in Rajendra Singh Rana case, read with Kehoto Holohan judgment 1992, my lord, it's very clear while a speaker sits on the disqualification of a member of the Legislative Assembly under Article or the MP 102 and 191 of the Constitution of India, then he sits as a quasi-judicial body, and he functions as a quasi-judicial body. Now here, my lord, here what happened, at least the bare minimum requirement of the learned deputy commissioner ought to have followed the procedure. And lordship law is well settled that procedural law cannot be a tyranny. But what it says is, the requirement is, my lord, to follow a fair hearing, my lord. Now kindly have this Rajendra Singh Rana, my lord.
Proceed, next.
Now, my lord, the final thing, why the entire procedure is vitiated by fraud is Article 32 of the NCP Constitution, which I am passing on, my lord.
NPC?
NCP, Nationalist Congress Party Constitution. This fellow doesn't have the power. The respondent number 4 don't have the power to initiate any proceedings, my lord, without approval of the higher authority, my lord. Discipline, my lord, kindly see. Article 32, my lord, discipline. For the purpose of maintaining discipline amongst party members and among party committees, a central discipline committee shall be appointed by working committee at the national level and discipline committee at the state level and the union territorial level by the executive committee of the party in the states and the union territory respectively, my lord.
We'll consider everything.
Now, my lord, therefore, kindly interfere with this impugn order.
Yes.
My lord, just concluding, my lord, because under this, the block president is
Don't conclude today.
No, no.
We will issue notice. You conclude on the final day.
I'll conclude it, my lord, kindly interfere with this. And then I will not make any rejoinder, submission, nothing like this.
No reason. There is.
That's all, my lord. My lord will interfere with this.
My lord, the undisputed fact is that the petitioner, he stood as a proposer for the rival BJP candidate, although he was a NCP candidate. That fact is not disputed. My learned senior colleague has made 3 legal points on the point of limitation. Secondly, that he was not given adequate opportunity of hearing. And thirdly, the complainant has no locus to file this complaint. My lord, in the first, on the ground of limitation, my respectful submission will be that the law of limitation applies to litigating parties to approach any court, tribunal, or authority. These are limitations applicable to the parties to approach. Now, in this particular case, the argument is that the authority who is duty bound to decide a case within a certain time frame, the law of limitation will be applicable to it. Now, in this statute, my lord, there are so many statutes where time frames are given to the authorities to decide cases, to do things in certain manner. Those are time frame given under a statute. Now, we will have to see whether this time frame, why these time frames are been given in the statute, whether it is to protect the interests of the petitioner or to protect the interests of the respondent. Now, in this particular case, the time frame is, to my respectful submission, my lord, is to protect the interests of the complainant, one who gives a complaint. The time frame is to protect his interest, that to expedite the complaint, these authorities should exercise in this manner. no prejudice is caused to the respondent against whom the complaint is made. So the limitation law which my learned senior colleague has given Kobe Etes and Jumkar Basar case, that is totally a different thing. Those cases, limitation cases.
It's okay. Why? Suppose if it is not done within, decided within 30 days.
Whether it becomes infructuous?
Whether it is a directory or this provision is directory or mandatory?
Mandatory. That is why, whether it becomes infructuous if the proceeding is not completed within 30 days. Just like my lord has already observed that in the RP Act, election case has to be decided. Petition has to be decided within 6 months. Whether the failure to complete it within 6 months will make it infructuous, whether the honorable court sitting will become functions officio in that event. No. These are time frames given under the statute to protect the interests of the litigants, who has instituted this, to expedite. So long as this does not prejudice the respondents, it cannot be said that this time frame, because the time frame has not been followed, it becomes infructuous. Now, the second point with regard to whether the opportunity of hearing was given. My lord, in the impugn order itself, my lord has said that he has appointed a counsel who represented, I think it's her. She has appointed a counsel who represented her. And in paragraph, page 43, the submissions of the respondent has been, the present petitioner has been recorded. And whereby clearly the counsel has stated that yes, the petitioner has acted as a proposer. He has put his her signature as a proposer for the rival candidate.
Yes.
And this matter, with regard to whether an opportunity of being heard is required in such established facts.
But see, if the law requires clearly that it should be decided within 30 days, there must be some reason why, even if we consider that, if we accept that it may be a directory, you cannot plot that also.
Yes.
And
that is a matter altogether. That's why I was submitting whether this time frame was given to protect the interests of the complainant or the person against whom the complaint is made.
It's not.
The intention of this
is what
time frame.
What cell in the section 2, section 6?
Yes, the intention of incorporating a time frame within a statute, directing the authority to act in a manner in a certain time frame, whether it is done to protect the interests of the complainant or to protect the interests of the other the person against whom a complaint is made. That has to be decided. I don't, in my respectful submission, these are time frames given to protect the interests of the complainant. And prejudice, if this time frame is not followed, the prejudice will be caused to the complainant, not to the person against whom the complaint has been made. Now, with regard to page 166, my lord, is the provision.
Where is 131C? I don't find it C.
My lord, 31?
C.
In the Principal Act, my lord?
31?
C.
No, my lord. There is 31A and 31B. Then 32.
The deputy commissioner has mentioned 31C. As far as commits defection with the meaning of 31B, read with section 31C of the Arunachal Shuvensu.
My lord.
And it has been inserted by amendment ordinance.
No, my
2006.
28/10/2025.
31C.
A member commits defection if in a Gram Panchayat chairperson election, she, after the issuance of whip by her political party, engages in a activity that undermines the party nominee. The response
Amendment, I don't find.
2006. Where is that?
2025. Yes, mentioned in the page 45. 31.
Ordinance.
42 is fine.
It's mentioned in
45
page 42 also.
Explicitly provides that. Member so and so.
My lord, at page 42, in the last para, section 31C is newly inserted by the Arunachal Pradesh Local Authorities Prohibition of Defection Amendment Ordinance 2025.
42. 26.
Page 42, in the last para. Promulgated by the Governor of Arunachal on 28 October 2025, published in AP Extraordinary Gazette number so and so, dated 29 October 2025.
Yes. It is not there.
Yes.
2003.
My lord,
Okay.
this matter, whether a proposer, once a person becomes a proposer, whether he or she will be liable for anti-defection, my lord, that has been already laid down by our division bench in Bengia Mania case, my lord. Long time back, my lord.
No, it's a explicit 31C.
Yes. 31C.
It is not there in the provision from where he has quoted.
It's ordinance.
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 My lord will kindly see same facts, my lord. Here the petitioners were ASMs, erstwhile ASMs and GPMs, who, despite being INC candidates, they became proposer for AITMC. In paragraph 16, my lord, we'll see whether the requirement of natural justice of being heard, my lord. Paragraph 16. The principle of natural justice are required to be adhered to in order to avoid prejudice to the party, which is proceeded against. If no prejudice is caused to the party concerned, mere denial of opportunity would not be sufficient to make a court interference with an act of an authority concerned if the act has otherwise been legally performed by the competent authority. In the present case, Deputy Commissioner Zero did not offer any opportunity of hearing to the appellants on their disqualification after affidavit has been filed, so and so on. Nonetheless, when the appellants themselves admitted in their so and so that they had become proposers of the AITMC candidate who was to contest the official candidate of their own political party, that is INC, the appellants cannot be heard to say that they suffered from any prejudice or that they had not voluntarily given up the party membership of INC, or that they had become the proposers of the AITMC candidate except for the purpose of seeing him victor or thereby waiting to see their own official candidate defeat at the hands of the AITMC candidate proposed by them. Then, my lord, referring to so-and-so, though Mr. So-and-so, Land Counsel for the appellants has contended that had opportunity been provided to the appellants would have urged that a solitary instance of an act as proposer of the AITMC ought not to be considered to mean that the appellants had shifted their allegiance from the INC to AITMC. Suffice it is to point out that when the acts of the appellants speaks for themselves, the fact that no further opportunity was given is really immaterial. In the present case, the solitary instance of the appellants becoming the proposers of the AITMC candidate was sufficient to give rise to a reasonable inference that the appellants had indeed given up the membership of their own party. Otherwise, they could not have become the proposers of AITMC candidate, desiring to make the AITMC candidate victor.
It's okay. On merit, on factually, they have admitted she was a proposer to
Yes,
the
my lord.
BJP
So,
Gram Panchayat chair.
prima facie, it's a, they have admitted that they have
But
become
it's a record of the deputy commissioner. We don't know where from we are saying that she was the proposer.
Yes, in the impugn order itself, they have admitted. My lord will kindly see the impugn order at page 44. Contention of the parties. A, respondent's submission. First is the respondent's submission. Page 44, my lord, that's seen. The respondent, though through learned counsel, admitted that she had casted her vote in favor of the BJP GPC candidate and had affixed her signature as proposer of the BJP nomination. This is the finding.
You should not it call for the records.
Yes, ma'am.
Yes.
Regarding the legal arguments, whether it's mandatory or the directory, that's definitely it's a directory nature. Otherwise, the lordship will see the anti-defection law. Why it was brought, it was brought because there shouldn't be horse trading, constant toppling up government, one member running from another party to another party. For that purpose, anti-defection was made. And legislature, they are quite aware of deputy commission functions, all the things as an administrative, as a collector, law and order duty, all those things. If suppose this is made directory, deputy commissioner might go for a leave and other personal things also. If this is called mandatory, that matter should be finished within 30 days, they are aware it cannot be. So it's a directory. So that the deputy commissioner expedites the matter and completes the hearing of anti-defection cases as early as possible. That's the only motto. Otherwise, it will defect the entire anti-defection law itself, for which purpose it has been brought in. And second thing, the specific pleading of the petitioner, para 13 and 14 is that they sought further time during the hearing, but they were not allowed. What does that mean? They know that the deputy commissioner could have given further time for them to adduce evidence and all that. He cannot blow hot and cold at the same time. Sometimes they say that.
That is where I am hesitating, my lord.
No,
I said,
you said you have undertaken not to reply.
No. that is what.
No, that's what I'm submitting. Because one side is says that within 30 days it has not been completed, and others, on the other hand, on paragraph 13, 14 said we have sought for further time, but it was not given. And it's a violation of natural justice, ori altrum partem and all that. This is their specific case. Otherwise, on the merit, definitely everything is clear. The defection, he has not even denied the defection in the entire petition.
It's a, the defection disqualification can be by way of summary proceedings.
Yes,
summary, my lord.
That is what I,
summary,
my lord, just, sorry for it. That's why, my lord, I made a categorical statement. While the deputy commissioner presiding the disqualification petition, he or she act as a quasi-judicial function, as a tribunal. So tribunal would mean willful case, my lord, will come into. At least this thing you should follow, and this has not been. And my lord, when this procedure started, my lord, this ordinance is there. I got the notification, my lord. The ordinance was promulgated on 28 October 2000, 26. Now, that under Article 213 of the Constitution of India. Now, this has expired. There is no further amendment. You cannot invoke this provision, my lord. No.
Which one?
This ordinance 3.1, which my lord was finding out in the impugn order, that particular notification which the deputy commissioner has relied on, the violation of the whip will entail this disqualifications. There, my lord, I have the notification 28 October 2025, it was issued. November, December, January, February, March, April. Now kindly see. So by that time, this has expired. And this has not been enacted in the law. So your redundant law you cannot invoke.
Otherwise, 3B is there. Otherwise, 3B is there.
3B is there, my lord. Kindly see.
Ordinance, we don't know. Yes, whatever the status, what is the status of the ordinance? Admittedly, ordinance was issued in October.
Yes, well, I have this.
Unless you
I have
reissued it,
they cannot. The life of
they can have reformulated.
Reformulated.
The expiry of the 6 months.
But this has already expired and there is no reformulation. So therefore, this cannot be.
We cannot believe you.
We cannot. No, my lord.
Because you are not the authority to promulgate or reformulate.
No,
we'll state only.
No, I'm not saying, my lord.
I'm not saying that.
I am respectfully
that's why
concurring
I'm
your
asking.
lordship's view.
Today they are blank. What do you say? Has it been reformulated? Reformulated?
Instruction I'll have to take. In any case.
Okay.
In any case.
Okay. This code is of the view that this to disqualify an elected member, I think summary procedure is not expected. At least the proper opportunity should have been granted. So till next date
it was given, my lord. It was given.
See, cause this list notice was issued on when? Within 12 days.
22
April, and matter was heard on 4th May. 12 days.
Yes, my lord.
Of course, there may be a mistake on the part of the council who represented the petitioner, but then
undisputed fact is that even if whether it's a detailed trial or a summary trial, the undisputed fact remains that she was a proposer.
My lord, it was reverted. I have spoken to the council who represented her.
Okay, heard Mr. Titi Thara, learned counsel for the learned senior counsel assisted by Miss MS Enriba, learned counsel for the petitioner. And also heard Mr. Anderton, learned additional advocate general for respondent number
1, 2, and 3.
1, 2, and 3, as well as Mr. Peter, learned senior counsel assisted by Mr. Tito, learned counsel for the respondent number 4. This writ petition impugns the order dated 28/05/2026 passed by the Deputy Commissioner, District Election Officer. Is he a district election officer?
Yes, he's also district election.
But the capacity of Deputy Commissioner or District Election Officer? Deputy Commissioner, K. Panya District, Yachudi, by which the petitioner has been disqualified as Gram Panchayat member.
Yes, Neoliberal.
Of the 4/8 Gram Panchayat constituency. Gram Panchayat under 04 Pistana Jila Person member constituency 16 Yachuli Assembly KE Panyo district Arunachal Pradesh. in exercise of, under section 3(1)(b) of Arunachal Pradesh, 3(1)(b) read with section 3(1)(c) of the Arunachal Pradesh Local Authorities within bracket Prohibition on Depiction bracket Act 2003. Mr. Mr. Titi Tara Learned Counsel, Learned Senior Counsel for the petitioner contains while referring to the papers annexed in the writ petition and also as well as the provisions of Arunachal Pradesh Local Authorities Prohibition of Depiction Act 2003 contains that the order has been passed in violation of the section 6 within bracket 2 of Central Act 2003, inasmuch as the Deputy Commissioner is required to decide the complaint as forwarded by the member secretary. Complaint regarding the disqualification as forwarded the member within 30 days from the after the receipt of such reference list of the member secretary referred the complaint against the petitioner for disqualification on when it was forwarded on 04/02/2026, whereas the impugned order was passed, impugned order has been passed on 28/05/2026.
89 days of windows.
List of the he submits that although a notice was issued on 22/04/2026, matter was taken up for hearing on 04/05/2026, without affording the petitioner a reasonable opportunity to defend her case. List of Mr. Tara, the senior counsel, further relying on the judgment of the judgment of this court as well as Honorable Supreme Court, submits that the what is that? What is call it? When a statute provides for an act to be done in a particular manner, it has to be done. What is that Supreme Court judgment?
Sigara Singh judgment, 1964.
Yes.
Yeah. para 8.
When a statute has conferred the power to do an act and has laid down the method in which that power has to be exercised, it necessarily prohibits the doing of the act in any other manner than that what has been described. Mr. He submits that in the present case, says that the petitioner has to decide the matter within a prescribed period of 30 days. Rather, within what 89 days windows.
30 days windows to decide the matter, and he took 89 days to take up the matter.
Another has taken 89 days in deciding the matter. The impute order is unsustainable. Mr. Then you say that in initially, Mr. TDs are well referring so and so. Primarily contains that. We are not record all this thing. Issue notice returnable by 4 weeks. 3 weeks, we'll make it 3 weeks. As the parties are duly represented. No form is the formal issuance of formal notice is waived. However, extra copies be furnished to the learned counsel for the parties. Next para. Hard on interim prayer. Next para. The petitioner was issued notice on 22/04/2026 as regards the complaint for disqualification, being a Gram Panchayat member on the ground of defection fixing the hearing on 04/05/2026. List of the Deputy Commissioner appears to have taken up the matter for final hearing on 04/05/2026 as fixed by notice dated 22/05/2026. Considered above, the petitioner appears to have not been afforded a reasonable opportunity to defend her case. Mr. As the matter pertains to disqualification under the defection law of an democratically elected member and Panchayati Raj system. List of in the privacy view of this court for proceedings of disqualification of an elected member appropriate proceedings, including the affording opportunity to the party sought to be disqualified has to be provided. This stuff. Accordingly. No, please stuff. The Deputy Commissioner appears to have decided the matter and have decided to take up the matter without adequate opportunity to the petitioner, as the matter was heard after 12 days of the notice. List of it is this court is not oblivious that the Learned Counsel appearing before the petitioner has admitted that the petitioner has cast her vote in favor of the BJP GPC candidate and affixed her signature as proposer of the BJP GPC chairman nomination paper, which otherwise would indicate reflects that there is prima facie a ground for disqualification under the defection law, under the aforesaid defection law. Christoph, however, the admission, unless shown to be authorized by the petitioner, may not be a proof of admission. To which, of course, this court would determine at the time of consideration of the issue. List of next para. That's all. Having considered about, among the considered view that an interim order is called for at this stage for the reason that prima facie is sufficient and the adequate opportunity appears has not been given to the petitioner before passing the impugn order. Coupled with the fact that the petitioner is a democratically elected Gram Panchayat member. Accordingly, till the returnable date, the impugn order that it's so and so shall not be given effect to.
Great. Obliged, madam.
Item number 2.
You just add one thing, democratically elected representatives should not be ordinarily unseated. Unseated. Ordinarily unseated. Democratically elected representatives should not be ordinarily unseated without due process of law. Yes.
By Lordship. Lordship, the petitioner here are the villagers of 3 villages of Taipong, Kovin, and Hangkap village, falls under Jarampur division in Changlang district. Your Lordship, they petitioner are praying for the special executive relief package towards right ROW for 132 kVA transmission line.
You have already received 50%.
50% Lordship. This
Before the amendment.
before the amendment.
How
Lordship,
can you claim now?
Lordship, they have
Is the amendment has the retrospective operation?
Lordship, they have issued a circular also. They have
It should cover the earlier cases also.
Lordship, they have issued circular in our name.
Saying what?
By name, we are been invited for the circular from the ADC.
100%?
Yes, for the 100%. I have annexed the circular, Your Lordship.
Where it is?
Circular is in Lordship. Page
But
number.
it's a reserve forest. Until the time it is reserved.
Lordship,
What is the circular?
it is on page number 84. 14 May 2025.
14 May
2025.
You had for some time. 84.
Yes, page number 84. Here are the name of the petitioner's Lordship.
Where is this?
Page number
That
84.
copy is page 85.
Lordship.
Is improvement on the meeting with the reform was and the land developers under the Jaipur's ensures in the conference of the
Lordship, they have again
2025.
Lordship.
Then
again they have issued another notification, another circular on 21st May 2026.
Saying what?
Stating that the compensation survey for the left out affected persons of COVID, Hongkap and Taipung village. They will be awarded the payment.
Where it is?
It's in page number 89.
The subject governors will compensate for left out affected persons of Kopin, Hongkong, and Taiping village on 25 to 8, 9. It's over now. They've done it or what?
Lordship, they have not done.
Then?
And still today we have not received our payment. We have not received our payment, Lordship.
No. This was issued on 21st May.
Lordship.
Not even a month.
Lordship, may please go to the about the payment they have made. The estimate.
When did you receive the 50% payment?
50%. It was on. It has been. There was no award was made, but the payment has been randomly debited into the account of the beneficiaries on the 2024.
You have not surrendered.
2024.
You have utilized. You have used it. It has come to your account.
Yes.
So
bit they have used and rest they have not availed till today. And in the context of the assessment report also, Your Lordship,
they are on the verge of considering your. I mean, they are under process of your claim. Conduct compensation survey for left out affected persons. Still, process is going on.
Lordship, we have again the protest petition has already been submitted also. We have submitted our protest petition also about this payment, wherein the compensation amount was never, it was not in the proper way. No SOP was maintained.
We'll see. Will issue notice? Or will you will obtain instruction?
May issue notice and keep open the maintainability of this writ petition because they are challenging the quantum of the award. Whether
how many?
Lordship, there's 35, including the petitioner.
The heard Mr.
Titatak.
Titatak, Land Council for the petitioner. By filing this writ petition, the petitioners 36 is number 36 or
35, Lordship, including the petitioner.
35.
Yes.
Including 35.
34.
35 in numbers.
35.
A resident of village, what?
Village, 3 villages, Lordship.
Residents of
Taipong, Kobin, and Honkap.
Taipong, no, Kobin, Hongkap and Taipong villages. Under, in Changlang district.
Lordship. In
Changlang
Jarampur Circle.
Jarampur Circle, Changlang district. Claims for pray for a direction to conduct re-survey and re-measurement of the land of the petitioner for calculation of the compensation.
Lordship, as well as the property, damage of the property.
As well as damage of the properties for calculation, for compensation on account of the construction of 132 kV transmission lines. As well as for payment of, and for payment of special ex gratia relief package towards right of way for right of way under the comprehensive scheme for strengthening of transmission and distribution system in Arunachal Pradesh, 2023. Please now. Next para, issue notice returnable by
Lordship, may please
4 weeks. You are appearing for all.
No, ma'am. I'll be appearing for respondent 1, 2, 6 and 7.
Yeah,
My friend will be appearing for 3 and 4.
Your Lordship, I'm appearing on behalf of Mr. El Parme, standing
In that
for
case,
power.
all are represented.
And I'm for the 3 and 4, Your Lordship.
No, therefore all are represented.
No, no. Power grid is there.
Where is the power grid?
PGC, Your Lordship.
Power grid. Respondent 5.
5 only.
Yes. Notice has to go.
5 only, right?
Yes.
Your Lordship,
Since Mr. N. Ratan, Learned Additional Advocate General, and Mr. Enters accepts and enters appearance on respond number 1, 2, 3, 4, 6 and 7. No. 1, 2, 6 and 7. And Mr. So and so.
K. Takar, Your Lordship.
K. Takar. Learned appearing for Mr. M. Perme, L. Perme, Learned Counsel, Standing Counsel, Power Department for respondent number. Respondent number 3 and 4.
3 and 4, Your Lordship.
No permit notice need be served. Our extra copies furnished to the students. The petitioners to take steps for service of notice upon respondent number 5. So and so by so and so.
Deeply obliged.
You record why keep it long? You are there, El Perme in place of the standing counsel.
My lord, the maintainability of the writ petition will be kept up.
As next para, as the learned edition raises the maintainability has raised the maintainability of the present writ petition. Same shall be considered on the next returnable day.
Obliged.
Item number 3.
My appeals, my lord.
Yes.
My lord, before come to the facts of the case, here in this case, my lord, still I failed to invoke the response from the respondent number 6. Respondent number 6 is the private respondent. Here the case is against the private respondent. Bond of contention is between myself and the private respondent. Appointment of the peon in the education department. So, my lord, as per the order of this honorable court on 28 October 25, it is confirmed that the service upon the respondent number 6 was confirmed.
Then
thereafter, respondent has not been appeared till today. Therefore, if this is if court permitted, this will be heard in absence of the respondent number 6. Otherwise, I was also support to file the rejoinder against the affidavit in opposition filed by the state. my lord.
So who is working?
My lord, respondent number 6 is working. My contention is that respondent number 6 is working in my place. Therefore, I am praying that
You regularized.
No, so far he has not been regularized, and I was also not regularized.
So go for press by selection, press selection process.
My lord,
No contingency business.
my lord, that part is there, my lord.
What is your stand?
My stand is, my lord, they have this private respondent, my lord, this has been appointed an administrative exigency, my lord, because earlier he was appointed.
The post it's a regular post.
My lord, just vacant, just
Vacant post.
regular vacant post, my lord.
Fill up.
But the contention of the petitioner, my lord, is that his service was not, his appointment was not, he was not appointed because the educational qualification for which required which he submitted is found to be fake, my lord. So we conducted the inquiry.
You have considered.
But we have considered it.
Now left open to the state respondent. Consider the case of writ petition Yaram Jamo.
Yes, my lord.
Who is Yaram Jamo?
My lord, me.
For appointment to the state vacant post of peer holding a fresh DPC as early as possible in accordance with the law.
My lord,
were earlier put up programs before this, whichever could not be held on the said that due to court case and pre of DC so and so. Huh?
My lord,
DPC.
That part we have done it, my lord. We recommended his name, my lord.
Her name.
Her name, my lord. But after recommending, my lord, DPC recommending, my lord, it was mentioned that appointment will be subject to the fulfillment of required other formalities, including
No, as per
education.
the direction of this court, see, considering the aspect of law as led by I would consider the appointment of private restaurant type to post of peon question is not in accordance with law.
Yes, in accordance,
that has been set aside.
yes, according with law, my lord.
That has been set aside. Terminating are hereby questions set aside.
My lord.
Now, to appointment said by holding a fresh DPC, that you have done.
Yes, we have done it. That part.
As per the direction.
Yes, my lord, as per direction.
Then
after, as per direction, my lord, we have done it at page 88, my lord, you see, of my affidavit, my lord. Page 88, the DPC conducted, last paragraph, my lord.
88.
Yes, page 88, my lord. In terms of the earlier order, my lord. Last paragraph, my lord. Considering the length of her service as a contingency staff and officiating peon, the committee recommends to absorb / appoint her in vacant post of Tagom Jerang, peon retired, subject to her fulfilling the eligibility condition for such post. This
what
was
do you mean by a peon retired? He has already retired.
No. This vacant post is it's against the retired, madam. That is on the retirement of the Tagom Jerong, the vacancy fallen vacant, madam. That seat fallen vacant, the post fallen vacant, and against which her case has been recommended.
Okay, DPC recommended her case.
Yes. Later on, my lord, before her appointment, my lord, the her educational qualification against, my lord, the complaint was lodged at page 89, my lord. And pursuant to this, on receipt of this, my lord, the authority, they have sought the detailed reports from concerned authority, from the concerned headmaster, which who had issued the educational qualification of class 8 pass, my lord, at page 91, my lord. DD has a short for official detailed response under RTI, my lord. Accordingly, this RTI reply at page 90, my lord, 91, it was clarified that she is not class 5 pass. Even she has not taken admission, my lord. And accordingly, thereafter, my lord, page 93, the inquiry was conducted by the DDSC, wherein inquiry, it was clarified that it was found that she's not, the document which she used is found to be not genuine, my lord, because she has never taken admission, my lord. And also she admitted the fact during the course of inquiry at page 93, my lord.
Then
and there are, page 93 is inquiry, my lord. And thereafter, page 94, after receipt of the inquiry report, my lord, Director School Education, they issued a so-called notice to the petitioner. But this so-called notice, my lord, in response thereof, no response has been filed. And accordingly, my lord, after issuing the so-called notice, page 94, the final order at page 95.
288.
Page 95 is final order, my lord. 94 is so-called notice saying that the class 5 passed. The earlier, as per 2008, my lord, the minimum education qualification for appointment of peon is class 5 pass, because at that point of time, class 5 pass was the board, state board. So that education qualification as per 8, RR 8, class 5 passed, and the educational qualification which he produced relied on for the purpose of her consideration of her case. Class 5 pass is found to be not genuine, madam. She has not taken even admission in class 1, madam. And later on, that RR 2008 has been amended in 2010, wherein that education qualification has been made as a matriculation, class 10 pass for peon or group C post, my lord. Then finally, my lord, at page 95, this is the final order passed by the Director of Secondary Education, my lord. Her recommendation, the appointment that has been, my lord, since the educational qualification is found to be not genuine and fake. Therefore,
she herself has admitted.
Yes, admitted, and accordingly it's been cancelled, madam. Now this order dated 21 September 2013, which is the final order, madam. This has not been put to challenge by the petitioner, madam. And no response to that effect, madam. Because he's not eligible, madam. And the document which
who is working on the post?
But now it's a private respondent, madam.
Private respondent.
Because on administrative exigency, madam, because he was earlier, he was there.
This your case has been considered, everything you are found to be fake certificate. But finish. What else? I thought after the earlier direction, they had not considered anything. In fact, they have considered
my lord.
Name was recommended.
My lord. So, what is remaining, my lord, at the relevant point of time, my lord, to that expect, I admitted that I could able to produce the class 5 certificates. Now, my lord,
have admitted that it was also a fact.
My lord, during that, my lord, even the respondent number 6 also the same certificate. He was also not that qualified one. And now at the relevant point of time, my lord, the recruitment rule pertaining to the class 10 pass was, my lord, since 2019. Now our case was, my lord, started in since 2010. Therefore, my lord, my contention is only that at the relevant point of time, since 2009, 10, and 11, that I was qualified and my case could have been considered.
See, that case, that certificate was found to be fake, which you have admitted. Your case has been considered and decided in 2013, when this writ petition was filed.
21, my lord, 2021.
You could have challenged this.
My lord.
2013. Copy to Jaram.
Yes, ma'am.
It's clearly given. Page 95.
My lord. That is there, my lord. At the time of filing, my lord, that was not brought before me, my lord. And this petitioner was
at best
unaware.
Otherwise, you'll be dismissing it. Tried, I don't know whether it is maintainable or not. You may challenge the 13 order.
My lord.
What do you say?
My lord, with liberty, my lord.
Disposal
Because, my lord,
with or withdrawal?
withdrawal with liberty, my lord.
Simply we said liberty.
My lord.
Because 2013, it's I think 2026 may not be possible.
More than 10 years.
They definitely raised the issue.
Yes, more than 10 years.
How old are you now?
My lord, almost 45, 35, my lord.
35.
My lord.
Still you have the age. Okay. No, not her. Mr. C. Modi, learned counsel for the petitioner. Submitted. He may be allowed to withdraw this petition with the liberty to file afresh.
If so advised.
In view of the fact that the case of the petitioner was considered by the respondent authorities. But finally, and consequently, the appointment of the petitioner has already been cancelled by an order dated 21/09/2013. Prayer is accepted. Accordingly, the petition stands closed on withdrawal with the liberty respect for. Secretary and the Standing Council Education Department is present.
All right.
Item number 5.
Lordship, hearing last time, this for the this determination of the land, order was passed, directing the ITBP to bring on record whether 17,900 square meters is under the ITBP, Lordship. Now they have filed the additional affidavit, Lordship. This is clearly, Lordship, reflecting paragraph, Lordship, 3, Lordship. May I read? That the deponent respectfully submit that the land measuring 17,900 square meters belong to petitioner form part of total acquired.
Just wait.
Last order, Lordship.
Yes, additional affidavit.
Yes, Lordship. On direction.
Respondent number 65256.
Yes, Lordship.
578. 678.
678, Lordship.
Where it is?
Lordship, this is already, I have received.
Lordship, it starts from page number 88.
88. Okay.
Para,
Lordship, it is clearly on para 3, Lordship.
Land measuring should belong to the forms part of total area and is been and But compensation has already been paid.
Lordship, only compensation is sanctioned against my land is done, but compensation is paid to Lordship Deputy Commissioner. But Deputy Commissioner and state authority has only compensated me for the 10,920 square meter, Lordship.
6,000.
6,980 square meter, Lordship, only on record, Lordship.
So in that case, compensation has already been paid by the ITBP.
Yes,
But
Lord.
while it was deposited in the, Deputy Commissioner, your claim is then against the Deputy Commissioner.
Lordship, in fact,
What this amount is called? Unit 10, 100, 1,000 lakhs, 12 crore, 14 lakhs.
Yes, Lordship, please come to page 93 of the additional affidavit. Lordship. Here they make it clear. Even I'm seeing and knowing from
93.
yes, 93. Here the donors list is the second list also. Only 5. Here the petitioner is at
7.
serial number 5. No, serial number in the second list, second down below the table.
Page? Sinway.
93.
What does it say?
But then
Now, what is as per estimates provided by you?
the compensation given to the persons, they are showing the 8 numbers in the above. So this serial.
It is also embedded on periodic expenditure payment of compensation of acquired land have been distributed to 8%. Then why 5 as per the estimate cost is provided by your office to ensure? Give a private measuring land
Lordship,
were
because
submitted as per details given and in addition to above the needing necessary.
Lordship, I have made the calculation in the parts table also comes to 99,462. And here in the second table also it is 9,462 square meter. Then in the first table they have brought in some people who are not in the second table, like this Pangmik Reba, Sri Pangmik Reba. He has they have shown them here having a land area of 48,773.50 square meter. And he has been paid more than 5 crore. Compensation paid amount as per this document. So
what am I trying to say?
no, this is a new document for me also.
So there's a discrepancy according to appears to be a discrepancy.
Yes.
So the claim of his 17,000 square meter, 17,900
square meter, Lordship.
900 square meter.
This is Lordship admitted
is shown to be correct.
Shown to be correct as per this.
But so far as the payment is concerned, ITBP is also clear.
Clear. And then
Now, how they have been paid? Why? At what rate? You don't have the.
No, rate is there 550 per square meter.
Okay, you are admitting that.
Yes, Lordship.
Admitting it's in our affidavit, Lordship. 550. But then only that here in first table also 99,462 square meters comes out. But then more people have been added.
You clarify that in that regard because we are not able to make it out whether she is entitled or not. Isn't it? Isn't it?
Yes, Lordship. Lordship, if your Lordship rise an order, Lordship, make it clear that the persons, the original landowners are the one in the second table.
Exactly, original landowner.
It seems to be.
See, in this connection, it is intimated on periodic expenditure statement, payment of compensation of acquired land have been distributed to 8% as per details below.
Lordship, in the last point number 5 also, there's some doubt was raised by the ITBP against this.
Full justification record.
Lordship, this is not my outlook, in fact. But only my claim is.
Well, you have not given this thing. You have not replied to it.
No, this is the additional affidavit.
No, I
I'm
have
also
filed.
seeing it today.
No, I filed
Okay.
in.
Lordship, petitioner have already annexed in their petition and it's in page number 33, Lordship.
33.
Yes, Lordship.
Lordship, I have already annexed it, Lordship. Page number 33, Lordship.
And in this regard, DC has not replied to us, Lordship.
Yeah, it's there.
We said that we have paid for 6,900 square meters.
But then we'll direct the deputy commissioner to clarify how the payment was, how the compensation was dispersed, manner and method.
Yes.
Heard Mr. G. Katolan, counsel for the petitioner. This court on 25/05/2026 directed the learned DSGI to bring on record as regard the claim of the petitioner of possessing 7,900 square meters particularly. In other words, whether the 17,900 square meters is part of the total area. What is total area of 99,462 square meters under the position of the ITBP? The stuff. No, on having found that, continue, the acquired area of the petitioner is 3490.45 square meters as per the communication dated 18/12/2017. Stuff. Next para. The respondent, ITBP,
yes, Lordship,
has filed the additional affidavit showing that, indicating that the land measuring 7,900 square meters claimed by the petitioner forms part of the total acquired land measuring 99,462 square meters, which is presently under the position of ITBP, for which a compensation of rupees 12,14,41,881 has already been paid. Page 89. Give me a second. Next para. On perusal, it is seen that the claim of the petitioner of a total land measuring 17,900 square meter forms part of the total 99,462 square meter. However, the payment of the disbursement shows that disbursement
Lordship, this may
shows
be
the,
affected again.
huh?
Serial number 4, especially what they have questioned.
It's okay, whatever. Shows the payment of rupees 38 lakhs 39,495 in respect of for the acquired area of 3,490.45 square meters. Which includes 7 other persons.
Lordship, may I
At the
clear?
same time, the petitioner is shown to have submitted details as regards the total area of 17,900 square meters. List of. It is also indicates that the Deputy Inspector General SHO within eternal applicable bracket clause has written a letter to the Deputy Commissioner on 18/12/2017 requesting a clarification the reason for distribution of the for disbursement of compensation to 8 persons including one Sri Pangwing Riba with full justification records. List of on pointed query of this court, MS G at the learned additional senior government advocate fairly submits that C is also not in a position to clarify as no instruction has been placed by the state respondents as regards the manner and method of payment of the compensation to 8 persons, including petitioner, showing different acquired land. Stuff. That's all. What you are saying?
No, Lordship, this 7 and 8 both are petitioners. This item number, serial number 8 is Tatak Bame is his brother.
No, it's okay.
So he is admitting that he have taken this.
Okay, that's not the issue. Issue is she is claiming 17,000.
Yes.
So admitting that 6 lakhs as 6,000 something.
6,980.
80, even if she has admitted. Rest how it has been, it has not been paid. How the 8% has been, including the agent, paid. And whereas the only 5% have already submitted the documents.
No, 7%.
So you take instructions, get it calculated.
7% have submitted. In
5.
Phase 4. No, CD 4.
5.
No, it says, Lordship, in 4.
1, 2, 3, 4, 5.
Estimate, no.
5% only, Lordship, not 8.
For acquisition, private limited showing so in view of MS as spread for and as spread for by MS G at then addition senior government to obtain instruction.
Yes.
Clearly indicating the manner and method of disbursement would be amount of rupees 12 crores so and so. Huh? To the affected landowners, including the petitioner.
Lordship,
And how and how the petitioner has been paid rupees 39,495 in respect of for an area of 3490.45 square meters, whereas the claim of the petitioner is for an area of 17,900 square meter. You clarify that.
Yes, Lordship, but then this 7 is the legalized people's, Lordship.
It's all right.
Only one.
No issue.
Yes.
See, out of this 8% also, it also comes around 10 lakhs, 10 crore only. 10
yes.
crore only.
Yes.
Whatever 12 crore. Whatever 2 crores, other 2 crores.
Every compensation.
Will not go into that.
Government takes
But then,
2% of
but
the-
then only would like to know when they are admitting that.
Yes.
See, her float is total area is
7,900.
7,900. Why only 6,000?
Yes.
Assuming that his brother is also, I mean, he's admitting that 6,000
Yes.
square meter.
Yes.
Admitted that. Rest why she has not been. So it appears that she has a genuine claim.
Yes, Lordship. One.
Let us see. You talk to you get the records and see.
Yes.
Appears to be something
One
fishy.
alien, only one alien person is here, Lordship. The
Mm.
receiver.
And Lordship,
That's the highest.
Lordship may kindly record my presence, Lordship, in order to this
Okay.
order.
Oh,
MS
For respondent number 67.
G. Gao.
Why
Gao,
Lordship?
Learned
On behalf of M. Kato, Lordship.
counsel appearing on behalf of me, M. Kato, Learned DSA is present.
Obliged, Lordship.
Much obliged.
Lordship, if it comes on 27 of 20th of this month, Lordship,
December.
Lordship, on this month, Lordship, not December.
That's not possible. She has to make up. He has to make up the things.
Thank you, Lordship. Yes.
So it will take time, not less than 6 months.
Lordship, let it be after this vacation, Lordship. 3 weeks.
At least after 4 weeks.
Yes.
That's Madam ensure. Something appears to be fishy.
Yes, Lordship.
Item number 7.
Lordship, this applicant is already retired from the government service, Lordship. In 2025, Lordship. It's been 6 months that pensionary benefit is not given to him, Lordship. And actually, he is permanently belongs from the Bihar. Now facing the problem, Lordship.
Lordship, I have received the instruction just this morning. We'll file our affidavit.
What does it say?
Lordship, I have received, it's not in instruction form, but it's in affidavit form. I haven't gone through.
Mr. G. Kato, Learned Counsel for the petitioner. Next, para MSG at Learned Addition Senior Government submits that she has received the instruction to which she would like to bring on record by an affidavit. April press for listing of the matter after 2 weeks.
Lordship.
Praise the Lord,
3
list
weeks.
after 3 weeks.
Lordship, 2 weeks.
2 weeks in a sense, it will,
Lordship, this is pension
it
matter,
will
Lordship.
go to
Facing
3 weeks only. No, it will go to 4 weeks.
no, Lordship, 2 weeks.
2 weeks, we say 2 weeks. It
Because
should be after 4 weeks only,
the
practically.
second time only, Lordship. On motion,
It's
it
a
was moved.
pension matter.
I understand, Lordship.
2 weeks, 2 weeks.
Obliged.
Immediately after vacation.
Lordship.
Item number 8.
You filed the affidavit.
Yes, we need time to file affidavit, Your Lordship.
Who has filed who is for respondent number 2?
I'm appearing for 1 and 2, Lordship.
You have filed, they have already
One,
filed.
yes, additional affidavit I have filed, Your Lordship.
So you would like to file on
Yes,
behalf of
proper affidavit, Your Lordship, I would like to file for 1 and 2.
You have already filed.
This is to bring on record some
Okay.
lordship documents, your lordship.
MS?
MLA. Your lordship, here respondent number 1 and 3 is, are required to file affidavit in opposition.
That is what she is saying.
She has already only filed to respondent number 2 only.
Mr. MS?
MLA.
MLA, London Council for the petitioners.
Yes, your lordship.
Uh,
I'm appearing on behalf of.
You are for 3.
For 3, lordship.
You also file.
Lordship, they have not provided us extra copy, lordship. And when we ask them to provide
This
us,
code is averse to that submission.
lordship,
That's in
no,
between you.
lordship,
You
last time.
submit the extra copy. You furnish the extra copy, sorry.
Okay, your lordship.
This court is rather allergic to that submission. Yes, madam. No extra copies, therefore no affidavit. Highly allergic.
No, lordship, on last occasion, we asked.
You furnish copy, huh? But not mentioning it, huh? On the prayer of MS, who is 1, who is 2?
I'm for 3, lordship.
Okay, R. Basad, London State Council, and MS Y. Gao, London Council, appearing on behalf of Mr. M. Kato, London DSJ. Further 3 weeks' time is granted to file affidavit in opposition.
Okay, sir.
Item number 9 and 10.
No affidavit. Respondent number 1.
1, your lordship. For 1, I need some time, your lordship.
Mr.
Your lordship, I'm for the petitioner, your lordship. I have a prayer to make, your lordship.
Yes, then you are also?
Your lordship, in item number 10. I'm petition.
You are 9.
I'm 9, your lordship.
Your
lordship, I have a prayer to make, your lordship, because your lordship, recently there has been some subsequent development in this case, your lordship. And to bring that on record, your lordship, I have to file an additional affidavit, your lordship. So I'm seeking your lordship leaves, your lordship.
Okay.
Leave from this court, your lordship. To file additional affidavit.
What about you?
Lordship, petitioner in item number 10 also has to file affidavit in rejoinder, lordship. And we have prepared, however, the read petitioner.
Okay, heard Mr. Sorry, not heard. Mr.
C. COVID, your lordship.
C. COVID. London Council with the petitioner in WPC. 523 of 2024. So your name is not there.
Yes, sir. I'm appearing on behalf of XGT, the conducting council.
London Council. A phrase for 3 weeks time to 2 weeks time to file additional affidavit in view of certain development in the matter. Praise the Lord. Listing matter. No, praise the Lord. Mr.
Tigao, lordship.
Tigaro.
Gao.
Your name is there?
Yes, lordship. No, lordship, in item number 10.
Appearing on,
In item number 10.
Tiga, Tanurga.
Yes, lordship.
London Council also prays for 2 weeks time to file affidavit in reply. The prayer of Mr. Gao is also accepted, is allowed. Accordingly, this matter after 3 weeks. MSD at the London State Council is also is present. Present only.
Lordship.
Item number 11.
Deeply obliged.
Much obliged.
May I please, lordship?
Yes.
I'm appearing on behalf of Mr. H.K. Jama.
Hmm.
He instructed me and informed me that he already approached the appropriate forum. Now this matter become in success.
Okay. Mr.
Amateur.
Amateur London Council for the petitioner. Appearing, your name is not there.
Yes.
Appearing on behalf of Mr. H.K. Jam, London Council for the petitioner. So Mr. Matter has become in process.
Yes, lordship.
Has become in process. The writ petition has become in process.
Yes, my lord. I'm for the respondent and the number 2.
Mr.
S. Shetty.
H. Land Council for respondent number
2.
2. You are 1.
Yes, sir.
Then MS P. Pangulan State Council for respondent number 1 and Mr. S. Chetri Land Council for respondent number 2 are present. Accordingly, writ petition stands closed as in process or become in process.
Item number 12.
Affidavits, no, yet to be filed.
You want to file?
Yes, I am for 1 and 2.
So, none appears to. The man very interested. Who is but a petitioner? This is about what?
It's about claiming of GST
Okay.
deduction return.
None appears for the petition on call. Office note indicates dated 22/06/24/6 indicates that neither the ID card nor answer notice has been received back in respect of respondent number 3. We have listed this matter after 4 weeks. In the meantime, Mr. Jithalan Standing Council, RWD. RW Department.
Yes.
RWD.
Railroad Department.
May file the affidavit, file the counter affidavit.